I'm here, Lordship. I'm here, Lordship, in the PC, Lordship. I may be excused.
Yes,
Yes.
just
Third in person, Lordship. Yes, Lordship.
some of the factors those have been taken into consideration by us in deciding the custody of the minor girl child are indicated herein. Stability and consistency in the affairs and routines of the child, and any dislocation may cause emotional strain to her, as she has been with the appellants since the age of 18 months as an infant. Marked eagerness in the child to continue to stay with appellant number 2, respondent and his wife, and their children, her siblings, and lack of any inclination to go to the custody of the respondent petitioner. No material was brought before the learned family judge to change the custody, apart from the fact that the respondent, being the father, is the natural guardian. It is admitted by the respondent that he never had custody of the child since he was an infant of 18 months. And the child grew up, remaining in custody of maternal grandmother, maternal uncle, and their family. And as observed in Athar Hussain, the consideration that the custody of the child should not undergo an immediate change has to prevail in the facts and circumstances of the case. For the foregoing reasons and discussions, the appeal is allowed, setting aside the judgment and order dated so and so. Application CP number 271 of 2015 filed by the respondent petitioner before the learned judge, Family Court, Berhampur, is ordered to be dismissed. There is an epilogue. Having decided as above regarding the custody of the minor girl child at present, before we part with the judgment, we would like to observe that there is always a hope that there shall be some opportunity for the father to interact with his daughter, who is now a minor. We also hope and trust, if in future there is any opportunity of interaction between the father and daughter, the appellant should not stand in the way, and in any event, the present proceeding was not regarding the visitation rights and contact rights of the father. It is quite possible that the gulf created between the families after the unfortunate demise of the mother would be bridged by a flux of time, and there would be a thaw in the relationship of the appellant and the respondent, so that there can be some opportunities for the respondent to meet and interact with his daughter. We hope such development would be in the best interest of the child to become a grown-up individual having her identity in society.
Good.
I agree.
So, Mahapatra, you counsel your clients because he's the father.
Let's grateful. Yes.
Yes.
Prescription item number 2.
Even though 7 lakh.
Please be on mic.
7 lakh draft I have given in
Pardon?
changing the name of Digbedi
Uh-huh.
in favor of my wife. 7 last. Clear.
Now you have brought the corrected draft.
Again.
7 lakhs. So therefore the only dispute remain to be installment. This remain to be installment of the rest portion.
Again. So our 17 lakhs.
What is the balance portion?
Our 17 lakhs. 17 lakhs.
Total is 17 lakhs.
Royal total.
And two equal installments.
I was praying for 3 pillars.
No, only thing is, what should be the best reasonable time to pay it completely? Because if you drag on this, then the other side also will be
Installment within 3 months.
within 3 months. Very reasonable, very reasonable.
Lordship. Or your lordship can say in 3 installment, 3 months. As your lordship.
Fifteen lakhs na 17
No,
lakhs?
10 lakhs.
So 10
Balance
lakhs,
amount is 70.
चारी चारी दुई कर दवा.
No,
After
this
7, rest is 24 million. Entire is 24.
ଆଉ କେତେ ରହିଲା?
ଆଉ 17
ଆଉ 17 ରହିଲା।
ଆଉ 17 ରହିଲା.
ଆଜ୍ଞା।
318. 17
ଛଅ ଛଅ ପାଞ୍ଚ
665 କରିଦବା.
ଆଜ୍ଞା ସେମିତି ହେଲେ ହବ।
As your lordship pleases.
In the commencement of the proceeding, following the direction of this court, dated 17/8/2023, in part compliance of the order, direction of this court, the husband appellant herein, by way of memo dated 25/8/2023, brings a bank draft, demand draft for rupees 7 lakhs on Union Bank in the name of respondent Sangeeta Dwivedi. Sangeeta Panda, but actual name Sangeeta Dwivedi. Drawn in the name of Sangeeta Dwivedi. এটা নেই, এটা কিন্তু আছে কেবল সংগীত making the draft in the name of Sangeeta Dwivedi. The draft is accepted as part compliance of the family court direction, and this court direct release of this draft in favor of the respondent through her counsel herein, Shri Pati. ये तो आचार्य आपनकर नाम थी कितने? ये रामदास आचार्य, अच्छी श्री रामदास आचार्य, appearing for the respondent today, keeping proper endorsement on release of such draft. Shri Acharya is directed to hand over the draft and file a consequence to the respondent and file a consequential receipt in the registry, at least within. Actually, the respondent is there available in court.
Not now.
So, how long a receipt can be filed?
Within a week, my lord. Within a week, my lord.
Within a week.
Lordship.
Okay, within 7 days as undertaken. You call her and hand it.
As your lordship.
Don't send it through registry post.
No.
Okay, now come to the এটা ଗୋଟେ order number separate ହେଇଯିବ ହେଲା. Then এটা କରିବ order number 5 ଗଲା, independent order. Next, on consent of the parties and keeping in view the limited challenge through the matrimonial appeal herein, seeking modification of the judgment annexure 1 in CP 390 of 19, only to the extent payment of the amount directed, the permanent alimony of rupees 24 lakhs as directed by the family court in phased manner but within 3 months hence. And clearing the whole amount within 3 months hence. In the course of hearing, this court find counsel for the appellant while making the deposit of the demand draft for a sum of rupees 7 lakhs, making a request to this court for at least granting 3 months time for making the balance payment of rupees 17 lakhs. In the course of submission, learned counsel for the appellant husband also undertakes to clear the balance amount of sum of rupees 17 lakhs, all within 3 months. Okay, see, this court records the submission of Sri Achari for the innocuous prayer involved within. And as the husband appellant is proceeding to work out the direction given by the family court in CP number 390 of 19 entirely, submits has no objection in the event there is grant of short time for working out the whole direction in the CP number so and so. Considering the rival contentions of the parties, this court finds there is already beginning of the compliance of the direction on permanent alimony by the husband on part payment of rupees 7 lakhs, and keeping in view reasonable offer of the husband further to ensure that the direction of the family family court Jashpur is wholly worked out. This court is of opinion to accept the request of the husband appellant herein by granting 3 months further time in release of the balance 17 lakhs. But a water भी सब ठीक से लिखे वाला. Within 3 months hence, for there is odd amount resulting payment in 3 months. I mean, this court to find a complete resolve of the dispute fixes the payment term, balance payment term as follows. The first, the whole amount shall be released in favor of the respondent wife within 3 months hence, meaning thereby by end of today's 25th na. So 3 months late, 24th of
November.
September, October, November. 24th of November, first installment of sum of rupees 6 lakhs to be released by 24th of September. On or before 24th of September. Similarly, the second installment of further sum of rupees 6 lakhs within 24th, on or before 24th of October. Okay. And the balance sum of rupees 5 lakhs shall be released on or before 24th of November. It is observed, since this court has interfered in the direction part in CP number so and so to the above extent, is constrained to observe failure of payment of whole amount within the time targeted the wife respondent shall be entitled to interest at the rate of rupees 8,000, 8% per annum in case of default. So please try to deposit within time.
Yes, sir.
Now with this observation, the order involved in Annex 1 is interfered to the limited extent as indicated herein above. The appeal does stand closed.
And this will all other proceedings initiated by the wife.
Any criminal proceeding there?
Execution.
तो अपन कौन केस
Any
अच्छी लिखी दियो तो स्लिप रे okay before parting letter
And
last year in the course of submission it has been brought to the notice that there has been some other disputes involving involving the between the parties involved herein arising out of the separation between the parties also pending in different courts. You provide the number so that we can indicate those numbers also on the full compliance of the direction herein. All such proceedings shall stand to be terminated automatically. On production of copy of the certified copy of the order of this court, direction of this court, the courts in assignment of any such proceeding shall do well in just declaring the proceeding closed.
And the amount of 10,000 which is being deducted,
Pardon?
amount of 10,000 per month which is being deducted from the salary.
No, okay, it is also observed on full compliance of the order. Direction of this court, okay. And the modified order of the CP. Now in the CP, there shall be no further need of. Okay, in view of the in view of the direction here in this court find there is no need of any further deduction
From the salary.
from the salary of the petitioner.
One thing, my lord, till the judgment is passed, my lord, but some arrear is there that he has to pay.
Area you find out that. That's not a subject here, please.
No, my lord, as my learned is submitting that.
permanent alimony consider
Permanent alimony ଉପରେ
ସେତେବେଳେ
appeal
area
ଆସିଛି।
କୁ stress ଦିଆଯାଉନି
Ah,
there is a clear strategy so that they also agree ଆପଣ ଯଦି ସବୁ ଜିନିଷକୁ ଧରିକି ଇଏ କରିବେ ଆପଣ
ନାଇଁ,
nobody is fully satisfied, neither you are fully satisfied, they are not fully satisfied, we don't expect also.
We don't advise even. Find out other options if any available.
Yes, ma'am, that.
କେତେ ଟଙ୍କା ଅଛି କି
ଲକ୍ଷେ ଟଙ୍କା କେତେ?
ହେଲା ଆପଣଙ୍କର enhancement କେତେ ହେଲାଣି ଆଚାର୍ଯ୍ୟ କେତେ enhancement ହେଲା
24 ଲକ୍ଷ ଟଙ୍କା ପାଇଲେଣି we have how much?
ସେଟାରେ କାହିଁକି ସେ ଯୋଉ
ନାଇଁ, ଏଇଟା ଆଉ
purposefully ସେଟା ତା ଦେହରେ add କରୁଛନ୍ତି
And ଆମେ ଏଥିରେ ବି deduct କରୁନୁ whatever money you have already taken. The money must have been paid. In the
Yes,
meantime,
salary attachment.
from the date of judgment,
Yes.
some money must have been deducted
Yes,
also.
sir.
from
Yes,
the
yes,
salary.
yes, ma'am.
automatic
Maybe
deduction.
2 months, 3 months, 4 months salary, we don't know.
And when you argue for the husband, you are saying that we have paid so much.
Content yourself. Don't fully go by parties.
No, my lord, as I have,
Self contentment would important ଜିନିଷ
I have also advised.
today we have pronounced that contentment ଦରକାର
Yeah.
Great.
Item number 3,
କେତେ ପାଲା ପାଣି ପିଇଥାନ୍ତା 10,000 ଟଙ୍କା Lord. Yes, item 3. Yeah.
May,
Yes, item 3.
may I please your lordship? Here petitioner,
Now this,
Eh.
yes, what is this case?
challenge.
This is Subuni.
33 C2
33 C2 order.
order challenge.
Both sides have already appeared.
my lord, that was final order passed, that was, yes, in this proceeding.
Okay, it was directed to serve copy on the other side. You are
Receipt
appearing
copy.
for the other
I'm-
side. There is fresh appearance or along with the other counsels?
Lord,
There is fresh appearance or along with the other counsels?
along with other counsel. Along with other counsel.
Along with other counsels, okay. It Ajir appearance record over na. Yes, argue.
My lord, the petition filed the 33C2 proceeding before the Lord and Labour Court, my lord, claiming that he is unpaid wages for 1 month and a retention benefit and leave salary claimed. And he has stated that he was working as an assistant general manager. And he is entitled to that amount, my lord. The bit
Is it in the connection of an adjudication, industrial adjudication or simply admitted dues?
Admitted dues.
that is
Simply admitted dues.
Admitted dues.
here, my lord, my contention
Your
before
management.
my lord, contention was there that he is not a workman and the forum, the forum is not agreed.
Can that be considered in a 33C2?
Yes, my lord. That is, if he is not a workman, so he cannot avail the
Please
proceeding.
show your written statement there.
Well-
Show your written statement there.
That is at page 20.
Yes, Annexure 3, you have filed the so cause.
My lord,
Hmm.
I have filed so much. You are assuming can
Annexure 3, page
page 20, my lord.
20.
My lord.
Come to that para where you have
My lord.
Page 21.
objected the
Pa- pa-
entertainability of the proceeding.
Paragraph 2, my lord. Paragraph 2. Lordship, paragraph 2, page 20, my lord. That
He is heading group of employees.
yes, my lord. He was assistant general manager getting the
So you dispute the quantum assessed only on the premises that he is not a workman.
he is not workman, he left the service without informing and as he violated the terms of the
Mr.
appointment
Chan,
letter.
kindly follow the question.
Ma'am.
Lordship's question is specific. Do you, apart from this ground that
Ma'am.
he is not a workman,
Ma'am.
do you dispute the quantum
Yes.
in the sense,
Ma'am.
do you say that it has been paid? Then you
Ma'am.
have to show that in the WS.
My lord, I have stated that he has violated the terms.
Sir, that point is very well taken.
My lord.
He left away, he's a bad person, he doesn't listen to you. We are not asking that.
My lord.
Do you say that this amount has been paid?
No, no. That is,
So that's the question because it's
Therefore,
not
there is an entitlement.
entitlement.
my lord. That
There is an entitlement.
entitlement.
And amount is too small, we don't interfere.
My lord.
Amount is too small, we don't interfere.
Question
my
of
lord.
law will be left open
Yes.
to be adjudicated.
If you raise
And
it,
Mr. Mishra was in the other side, from the management side in the other case. He was wearing a different hat that day. Today,
today you are facing that music and he is opposite. So therefore, we don't interfere. Question, if any, will be left open to be decided in appropriate proceeding. And we decline to interfere in the order for the meager amount involved there.
Because this is the proceeding, he has filed 33 from only this is the proceeding. There is no other.
can be filed for admitted dues.
Well,
With your vast experience, Mr. Chan, 33C2 can be filed for admitted dues without determination in a part 2A2 or a reference.
This is the execution proceeding.
33C2 can be filed or not?
Yes, can be filed.
So
Yes.
he cannot take advantage in any other proceeding. That
No,
also will
then-
clarify. My lord was telling that
Then-
only.
So,
That he will not be treated as a workman in any other proceeding.
the another proceeding, in this proceeding also, if he is not a workman, so he cannot avail the forum, my lord. This is the jurisdiction.
Mr.
Jurisdiction is
Chan,
If you go to the Supreme Court, how much money you have to spend?
again, how much money
That
is
my
he
lord
spending?
always tells me that
He can very well, you admit that he can very well come in a read petition and get this entitlement. It will be abuse of process again, unnecessary. Why? If you admit, why are you not volunteering?
Well, he can file the civil.
So we record your
or
submission.
claim,
We record your submission.
other proceeding, there is
I
also
had the submission of
civil proceeding, my lord.
learned counsel for the management hearing. Also in the involvement of submission of Sri Shivashish Mishra, advocate, along with the other advocates already appeared for opposite party number 2, the workman, and Sri Ghosh, you are there, or Sri SAHOO. Samaste industrial adjudication lawyer is how? SAHOO learned counsel appearing. Idea ଦେଖିଥିଲେ କେବେ? ଦେଖିଛନ୍ତି? ଆଚ୍ଛା ହଉ। ନାଇଁ, this side I can't put that question. Very rare, very rare. Law ରେ ଥିଲା, labor law subject ଥିଲା?
Yes.
Oh, then that should not be any doubt. All of us, submissions of respect. Please take your seat, all the counsels. The requisition involves a challenge to the. So now final part टाକୁ लिखिदियो, ମୁଁ बाकी घरे डाकिदेବି. ଲେଖ. The considering the main thrust of argument of Sri Chand that undisputedly the management through their so-cause raised the question of entertainability of the proceeding for the workman herein not being a workman and was functioning in the managerial capacity. Taking this court to the observations of the industrial adjudicators in a 33C2 proceeding, the Chand thus there has been no proper consideration of the pleadings as well as evidence available on record. The Chand in the course of submission, however, brings a further challenge to the proceeding on the premises while not strongly disputing the entitlement aspect, but submits since the workman herein is in entitlement to bring appropriate proceeding for such entitlement. No benefit should have been flown by way of an exercise undertaken under section 33C2 of the ID Act. Okay. This court here considering the aforesaid objections find. Finally, there is involvement of a meager sum of rupees 1,22,000. There is, of course, no serious allegation or objection on the entitlement of the workman herein, the opposite party number 2 herein. Merely because there is further scope for the workman, the OP number 2, to have such exercise through any other proceeding may not stand as a ground to object to the ground to interfere in the impugned order. This court, however, while declaring interfering in the impugned order for a meager amount involved herein, and there is no serious dispute that OP number 2 would have achieved such relief through other suitable proceedings. Leave the question raised herein on the entertainability of the dispute open to be adjudicated in appropriate proceeding. Further, for the limited exercise of the court, keeping in view the peculiar nature of facts and background involved therein, Further also to avoid further wastage of time to any other legal proceeding undertaking such exercise. This court also observed the direction herein declining to interfere in the impugned order in the peculiar circumstance shall not stand as a precedent in involving pendency of any such proceedings. This observation, the repeats and stand disposed.
That's it. The first part will be dictated in the chamber.
Lord, I must tell
Factual
your
aspect
lordships
will-
one thing, because if your lordships comment that he is not a workman, then
No, we don't hold.
because
We
there-
don't hold.
because there are evidences which have been led, there are on
Could
his
be the
on
nature of job again, the same.
and even
We
the
don't interfere in the order,
Right.
but it will not be a precedent. How are
Very
you
well.
affected?
very well, very well,
And we keep the question open. Suppose in
Very
some
well.
other case
Very
they
well.
bring such issue.
very
May
well,
not be in your case. That can't be in your case.
very grateful, very grateful. Because the only apprehension is
But here they have specifically stated the nature of job.
they have said, but that has
Like
been
the
dealt with.
the matter you were arguing in page 94 of that brief, it is specifically stated.
That is specifically dealt with by the labor court.
Okay, we'll come to
And
discuss.
even
We'll
Labor
discuss.
court
also.
is giving him one line.
Very well. I'll leave it. Very grateful, Miller.
Item number 4.
I am challenging the award passed by the.
Just a second, Mr. Miss. Just kindly use the microphone also, because you are at the, towards the left of the
Yeah.
microphone.
Factual aspect. That- Yes.
May I please, Your Worship? I'm
Yes,
challenging
Mr.
the
Biswanath.
award passed by the presiding officer Labor Court in an
के
industrial
out के mic out down करो.
impugned is the award of the Labor Court, wherein it has held that my termination from service as a cook.
Just,
from attendant-
before you proceed, Mr. Mishra, you are all new to these subjects. Where is the certified copy of the award? Or at least a communicated copy?
But, I'm
Why do
sorry,
you keep
perhaps-
it with you?
No,
If
perhaps
you
I-
challenge that, should you not file
I
that?
did not take note of the defect.
It is happening every day. कौन करिया ऐसा? कौन list रे circulate करिवा?
The
Council
communicated
side
copy is
request.
there, my lord.
दियन्तु memo. हमू देई दियन्तु आमे record रखू. ସବୁ case ରେ ସେଇଆ କରୁଛୁ, certificate. File କଲେ very ସୁନ୍ଦର file କରୁଛନ୍ତି.
File, my lord. Communicated copy with a seal.
ଆଜ୍ଞା ମୁଁ ଆମ brief ରେ ଯିବି ନା ଆପଣଙ୍କ କହିବାରେ ଯିବି. It is just a xerox copy.
No, that is seal, my lord. Your Worship, kindly see, seal is there, original seal.
এটা High Court ର seal ଟା.
That on the photocopy they have put they should not have.
Should not have, my lord.
Photocopy of the stamp, they have again re-stamped it
Yes.
with a blue, so it is not very clear.
Share କରିଦେଇଛନ୍ତି ପୁରାଟାକୁ.
They should have put a separate stamp, as it is done here also. Separate
Right,
stamp
right.
at a
All
separate
right.
place.
We don't go by that. Okay, argue.
My lord, the petitioner, my lord, may.
You are management,
No. I am the workman. I was appointed in the year.
so you lost the proceeding even in spite of management is expected.
Yes, that is the agony, my lord. Management has throughout remained absent before the conciliation
So, all right,
officer
what was
also.
the reference?
Reference was as to whether the termination of the petitioner is whether the action of the district welfare officer Sambalpur in terminating the services of Benudhar Bhai
The
sir.
termination of service.
Yes, my lord.
And on your pleadings and the evidence, the labor court
Labor court has
has
not at
come
all.
to hold that you don't have a case.
Yes, That is my grievance, my lord.
Oh, what-
Labor court has not referred to any of my
All right,
documents.
it's a workman, you are issuing notice.
My lord,
Admit kar the call for LC. Requisites has undertaken by day after tomorrow, by Tuesday.
the records may kindly be called for. Records.
You have
Already that order has been passed.
Obliged.
At least this bench doesn't commit that mistake. Once one matter is admitted, record has to be
Automatic
called
has
for.
followed.
Previously, prayer ରେ ଲେଖା ହଉଥିଲା.
ଆଜ୍ଞା।
ଆଜିକାଲି ଆଉ ଲେଖା ହଉଛି କି
ମୁଁ
ନାହିଁ?
ଲେଖିଛି ପ୍ରେୟାର ଲେଖା ହେଇଛି
NCR called for ସବୁ
ହଁ,
prayer.
prayer ରେ ରହେ.
ମୁଁ ଲେଖିଛି
But many courts
ଶେଷରେ
are
proceeding ମାନେ
not following that. Then ultimately, I have dismissed some arbitration proceedings on this ground, because arbitration appeal comes after 30 years for hearing. Maybe decided 20 years back or 15 years back. Now, from whom I will get the records? The judge might have expired or
The records might have been destroyed.
sold his waste papers. I can't even call for record. So on that ground, because the argument were advanced sometime on the basis of some documents. Sir, original is there, already filed. Original is untraceable. I dismissed, some party went, central government went to Supreme Court confirmed that order. Said yes, it's a genuine case. If you are interested to canvass your argument on this basis, you should have ensured production, or at least you should have kept a certified copy. Even certified copy was not there. Mr. Bose, Anup Bose, Central Standing Council was arguing. So we have done that.
Right.
Right.
Item 5,
Sarno Srinivas Mishra endowment. And
I'm the under labor court.
I need to get with them.
Person before
In
London Labor
person.
Court. So I had filed an application, section 36, 3 and 4 for ID Act 1947. Requesting the Labor Court to direct the non-applicants to appear as per the
Just
provisions
go
of
slow,
section
go slow.
36(2).
Okay.
You are the
Aste.
workman.
Yes, sir.
You are the workman.
Yes, sir.
Workman, it is in a 30. What was the nature of proceeding?
Sir, this is the ID Act under section 36.
Under section 36,
1, 2, 3, 4.
1, 2, 3, 4.
Yes, sir. Where is the
It is on representation of party.
yes, sir.
There is the idea there 36. What was your application? Where is that application rejected here? Annexer kete?
Annexer 2, ma'am, 2, sir. In the last page, page number 21, 22.
Yeah, monopoly without representation. There he filed, maybe sought for representation through counsel. Representation. That has been rejected.
Yes, sir. In the Annexer 5.
ଆପଣ ସେଠି ମଧ୍ୟ ଇଂଲିଶ ରେ ଆର୍ଗୁମେଣ୍ଟ କରିଥିବେ ସେ କହିଥିବେ ଇଜ ଏ ନଲେଜେବୁଲ ପର୍ସନ ହ୍ୱାଟ ଇଜ ଦ ନେସେସିଟି ଅଫ ରିପ୍ରେଜେଣ୍ଟେସନ
ନାଇଁ ସାର୍ ମୁଁ ସେଠି ସେଠି
Ah,
clear
yes,
ପଚାରିଲା-
obviously somebody carried away with an impression. You need not require any assistance.
Sir.
So therefore you should have been careful. What is that Supreme Court decision supporting you?
Sir, that Annexer
Management since always loaded with intelligent persons educated persons, the workmen should not be left to mercy.
Because I am the terminated from the service, that's why I was
judgment
not able
ଆଣିଛନ୍ତି କି?
to give the.
Judgment ଆଣିଛନ୍ତି ଆପଣ ତ ଇଂଲିଶ ରେ ଆରମ୍ଭ କଲେ argument ଆମେ ଦେଖିଲୁ you are a knowledgeable person.
No, sir, I am not so much knowledgeable to law. I am
ଆଉ
profession
ଇଂଲିଶ
of
ରେ କାହିଁ
medicine,
ତାହେଲେ
sir.
ସେଠି ଯାଇ କରୁଛନ୍ତି ଏଠି କରୁଛନ୍ତି?
Nahi, sir.
Admission ରେ ପଠେଇଦେବା fixing short returnable date. What happened to the proceeding? ସେଠି ଯୋଉ proceeding ଟା ID case ସେ କଣ ହଉଛି?
ସେଠି sir ବର୍ତ୍ତମାନ next date ଅଛି 1st September କୁ ଅଛି first
କଣ ପାଇଁ ଅଛି?
written statement ଦବା ପାଇଁ
Of the management.
Yes, sir.
You have, so it's a 2A proceeding.
Sir.
It's a ଆପଣ 2A ରେ ଧାରାରେ କରିଛନ୍ତି
Sir,
industrial
sir.
not a reference.
ନା sir.
2A ରେ କରିଛନ୍ତି all right there shall be stay of further proceeding. Of ID case 10 of 23 till next date ହେଲା. Main case ରେ କରିଦବ the matter may be post for involvement of short question involved. The matter may be posted immediately at least 7 days after the appearance of management. For there is a statutory proceeding involved herein, there is no need of filing counter. The argument will be advanced merely on the basis of the documents already available on the court. ତାପରେ interim order ଟା ହବ ନିଷ୍କର୍ଷଣ ଠିକ ଅଛି 36 ରେ ଅଛି There is stay of further proceeding of the ID case.
Sir.
And matter is directed to be posted immediately after the appearance of the management.
Sir. Sir, ଏବେ sir.
Okay. ଆପଣ requisite file କରିବେ. Requisite as undertaken by Tuesday. Requisite file କରିବେ.
Sir, ଏଇଠି କରିବି ନା.
ଆପଣ ବୁଝିବେ
Sir.
ପରାମର୍ଶ ନେବେ ଓକିଲଙ୍କଠୁ
Sir.
ସବୁ ଆଉ ଆପଣ କରିଦେବେ କହିଲେ ଓକିଲ ଏଠି ଆଉ କଣ କରିବେ?
I am ready.
ହଁ।
Sir.
For orders item 6.
I pray for short urgent.
Yes, it is a bail application. It is appeal pending 2014.
My lord.
Conviction date. And what is the period of
11 years. 11 years.
11 years? कौन धर्म करथिले 302
ଆଜ୍ଞା
302 ना 376
ନା ନା 302
302 का ପାଇଁ ବେଲ ମୁଭ କରୁଛନ୍ତି ଦି ଜଣ ଯାକ
ନା ନାଇଁ ଜଣେ ଆଜ୍ଞା ପଳେଇଛନ୍ତି ବେଲ ଅଶୋକ ନାଥ ରିଲିଜନ ବେଲ ମ୍ୟାନ
କିଏ ରିଲିଜ ହେଇଯାଇଛି
ଅଶୋକ ନାଥ
Appellant number 2.
2 ମ୍ୟାନ
ହେଇଯାଇଛି one only
1
Earlier
11 years ହେଲାଣି
Again. That is the only ground. Otherwise, my lord, the earlier rejection order you will also will see.
appeal not being possible
ସେଟା ହେଲା 16/12/2019
ସେଟା
Reject ହେଇଛି।
ମୁଁ ଥିଲି କି
ନାଇଁ ନାଇଁ ଆପଣ
Okay.
କୋଅର୍ଡିନେଟ ବେଞ୍ଚ
ସେଇଥିପାଇଁ
16/12/2019 ରେ
ଠିକ ଅଛି
Appellant number 1 is the main accused, my lord. I am for the informant.
ହଁ ରାଇଟ୍ ହେଲା ଆଉ 12 ବର୍ଷ ହେଲାଣି ନିୟରଲି 12 ବର୍ଷ ରହିଲାଣି ଆଉ କେବେ ହିୟରିଂ ହବ ତା ଠିକଣା ନାହିଁ every now and then you find there is acquittals only so who will compensate yesterday there is some acquittal in Supreme Court after 29 years the entire life of the man gone this is a normal order we passed there is no special attention to this client at the submission of all the counsels involved within. Considering the ଭିତରେ ଅଛି ବାହାରିଲେ ଯଦି appeal arises out of a order of conviction and sentence dated 14/11/23. Statement of parties discloses appellant 2 is already released on bail and appellant 1 is only in jail. Since kebetu achi? kebetu se jail re achi? Kane eta to judgment 13 ବର୍ଷ ହେଇଗଲା.
4/7/2012.
Since 4/7/2012, this is a trial of which year?
My lord,
12 rounds.
12.
Since 4/12/2012. 4/12.
4/7, my lord.
4/7.
My lord, 4th July 2012.
Okay. There is already the appellant appears to be already in jail for more than 11 years. For the pendency in criminal appeal side, this court find it is not possible in near future to undertake the hearing exercise of such appeal. Well, considering the length of jail already suffered by the appellant, other appellant already on bail, no chance of early hearing, this court is inclined to grant bail to the appellant number 1, number 1, petitioner number 1 hearing in the line of the the appellant may be released, appellant 1 may be released on bail by the trial court, subject to, however, following conditions: on furnishing bail bond to the tune of 20,000 with 1 surety to the like amount. Further, also with condition not to leave the district jurisdiction without permission of the trial court. Further, any single incident threatening any witness or the informant herein shall entail in automatic cancellation of the bail order herein.
As per the direction of the Hon'Ble Court,
Pardon?
as per the direction of the Hon'Ble Court, I filed my income and expenditures as per the Rajneeshan Nest case, my lord. But the respondent has not filed his affidavit.
I have filed it, your lordships.
So this is for final hearing.
No, your lordship, it's for interim maintenance.
Interim, I am paying my lord 25,000 for service.
So under section 24,
your lordships, they are pursuant.
what is the judgment involved?
Again, judgment which divorce was disallowed and maintenance of rupees 25,000 was allowed.
20,000 per month.
25,000 per month.
For the wife and the child.
Hmm.
But they are paying only 10,000. Say they are not complying with the judgment. As on date, dues is about 3 lakhs. That apart, your lordships. He is earning 1
So
lakh
now
plus.
what is your application?
My application I filed for an interim maintenance, your lordships.
Interim maintenance is already in grant.
My lord, only 10,000 is outstanding.
Let her complete.
Let him.
Yes, come to the judgment part.
Again,
That part of the judgment. Yes,
I've sought for enhancement, your lordships.
that's
Only-
right. So your case is for enhancement.
Lordships.
So don't say enhancement of the interim maintenance.
Yes, your lordships.
Interim maintenance.
Yes, your lordships.
ये तो से 25,000 भी दौना
नहीं आज्ञा, 2
अब
lakh.
आपण
He's
enhancement
earning
कौन पाई
1 lakh, 1.5 lakhs, your
that is
lordships.
the subject of course realization
Yes, your lordships.
आपण execution करिवे तार
Execution, again, चालीची separate.
what is he doing?
He is a dental surgeon, your lordships.
He is
Dental surgeon.
a government employee?
Yes, your lordships.
Government employee.
He's in the hospital, yes, your lordships.
So let us first attach his salary.
Again,
I'm a
Let us
contractual
first
employee.
attach his salary to ensure.
I am
you-
contractual.
It is whose appeal? It is whose
My lord,
appeal?
Wife's
she-
appeal, as I have filed one appeal
Hmm.
challenging the quantum of maintenance.
Hmm.
They have filed two, quantum as well as for divorce.
So quantum, is there any stay of the judgment?
No, your lordships. Judgment has not been stayed.
₹10,000 ଜମା outstanding ଅଛି on
ନାଇଁ,
today.
ଆପଣ
I-
10,000 ଦଉନାହାନ୍ତି ବୋଲି ତ ସେ କାଇଁ
ନାଇଁ ନାଇଁ 25,000 ଲେଖା ଦଉଛି 10,000 as on today is outstanding.
ଦେଇଛନ୍ତି at least what you can do.
Yes.
Bring an affidavit.
I have filed an affidavit.
So the
my lord.
Lord's
Your
counsel.
lordship- My
That
your lordship,
can
hear-
be.
hear me for a moment.
So you have filed that affidavit.
I have filed already
Okay,
filed
okay,
that.
that's go slow. ଆପଣଙ୍କର ସବୁବେଳେ ଗୋଟେ rocket ଭଳିଆ ଆପଣ move କରନ୍ତି.
I have filed that.
Please,
I
please go with the court.
yes, my lord.
Please go with the court.
Yes.
Yes.
I have filed the affidavit.
To her claim of allegation of non-payment of interim maintenance,
Yes.
you have brought an affidavit disclosing that
Yes.
you are going on paying,
Yes.
but however, there is a outstanding of 10,000
Only
only.
10 as on today.
Okay. Now, have you filed any objection to that?
Yes, your lordships, I have filed
You
it.
have filed?
Yes.
So it will take some time.
Yes, your lordships.
Okay, we don't have that time.
I oblige that. I'm
No
not.
objection has been filed to that effect, my lord.
Je କହୁଛନ୍ତି file କରିଛନ୍ତି।
It is in respect of that
ବି
matter.
ପାଇନଥିବେ ସେଥିପାଇଁ କହୁଛନ୍ତି no.
I have served.
ହାଇକୋର୍ଟ
copy.
କପି ଦେଇନଥିବେ ଆଉ ଥରେ ଦେଇଦେବେ ଆଉ ଥରେ ଦେଇଦେବେ ଆପଣ ଯାହା ଯାହା କପି ପାଇବା କଥା ଦେଇଦେବେ
ଦେଇଦେବି ଆଜ୍ଞା, that is not disputed. I'll
Let's
serve another
place
copy.
this matter 2 weeks after.
ଆଜ୍ଞା।
ହେଲା କାରଣ ଆମେ final hearing ରେ କିଛି matter ଅଛି।
ଆଜ୍ଞା।
So we have to reach there ହେଲା। Okay.
Oblige your lordships.
ସେଇ orders ରେ ଆସିବ।
ଆଜ୍ଞା।
ଗୋଟେ date କରିଦିଅ ହେଲା।
Oblige your lordships.
In the meantime ସେ 10,000 clear କରିଦିଅନ୍ତୁ।
10,000. 10,000 or less. There execution.
Yes,
Stay of execution.
stay of execution in which his salary was attached.
No,
ତାଙ୍କର
yes,
appeal ରେ ଲେଖ ହେଲା considering that there is some obstruction in the payment of the interim maintenance in grant by the trial court for pendency of appeal, even though this court doesn't want to enter into such controversy at this moment, keeping in view the objection raised by Sri Mahanti, counsel appearing for husband, this court only clarifies to the extent pendency of the appeal may not stand as a bar in the proceeding of the execution process.
ଆଜ୍ଞା।
In the further proceeding, in the execution.
Further proceeding, execution is-
ଥିବ ଦେଖିବ ଗୋଟେ case ରେ
Right.
order ରେ ଦେଖିବ।
You will also state that
Right.
for the proceeding of execution.
So 10,000 ଯଦି ଦେଇଛନ୍ତି that will
10,000
be
ଦେଇନାହିଁ ମୁଁ
resolved
affidavit ଦେଇଛି clear affidavit file କରିଛି 19/12 ରୁ 10,000 only
ଏ
outstanding।
ଭିତରେ ଦେଇ ଦିଅନ୍ତୁ better।
ଆଉ 10,000 ଟା ଦେଇଦେବିନି କି 10,000 ଦବା ପାଇଁ ମତେ
ଦେଇଦେଇକି ଆର date ରେ file କରିଦିଅନ୍ତୁ ଯେ ଦେଇଦେଲେ ବୋଲି ହେଲା।
10,000 ଟଙ୍କା ଦେଇଦବା ପାଇଁ
ଏବଂ ତା ଭିତରେ ଆଉ ଗୋଟେ ମାସ ହେଇଥିବ ଯଦି ଆଉ 25,000
ଆଉ 25,000 35,000
ଦେଇ ଦିଅନ୍ତୁ ହେଲା ସେ
ହଁ।
ଚଳନ୍ତୁ ତାପରେ ଦେଖିବା
ମୁଁ
enhancement
ରେଗୁଲାର
issue।
ଦେଇଛି affidavit file କରିଛି there is no
And
absolute
both
no
parties should be ready
ଆଜ୍ଞା।
instead of fighting on
I
this
think it is
interim maintenance. If matter can be resolved,
Resolved ହବନି ଆଜ୍ଞା, mediation କୁ refer ହେଇଥିଲା।
ନାଇଁ resolve ହବନି ମାନେ reunion ହବନି।
ନାଇଁ ହବନି।
Reunion.
So say that
Yes, your lordships.
resolve by way of reunion is not a
Not
possibility.
Lordships.
So what will be the course left
It can
upon?
be disposed of.
Alimony? Alimony only?
Yes, your
So
lordships.
alimony ଉପରେ argue କରିବେ
ଆଜ୍ଞା।
ରଜନୀଶ ନେହାର ନେଇ ଆସନ୍ତୁ
ଆଜ୍ଞା।
ଆମର ଜଜମେଣ୍ଟ ଟା ଦେଖି ଦିଅନ୍ତୁ ଶୁକ୍ରବାରର ଆମେ ଜଜମେଣ୍ଟ ଦେଇଛୁ ଦେଖି
ଆଜ୍ଞା।
ଦିଅନ୍ତୁ
ଆଜ୍ଞା।
ସେ ଫର୍ମାରେ ପକେଇକିରି କମ୍ପେନସେସନ ଟାକୁ
ଆଜ୍ଞା।
ବାଲାନ୍ସ କରିଦବା
ଆଜ୍ଞା।
ଗଲା କାମ ସରିବ।
as your lordship as an interim measure what your lordship passed the order my lord.
Execution.
ଆମେ କହିଲୁ ଯେ pendency of the appeal
Yes.
should not stand as a bar in the proceeding
Execution.
in the execution case.
Oblige your
It's a absolutely abnormal law. Normal ବି ନୁହଁ।
ସବୁ ଗୋଟେ ପଇସା ବି ମୁଁ ରଖିନି ଏ ମାସରେ 50,000 ଟଙ୍କା already
ବଢିଆ ଠିକ ଅଛି you do a mercy after all your wife.
my lord I am an contractual employee at any moment
ଆଜି କାହିଁକି
amendment application for the prayer only to the limited extent of I have challenged the decree, in fact, missed the word to the extent of permanent alimony. And the wife has also filed an
You
appeal,
have brought an amendment application.
my lord.
To
I-
what extent? It is therefore prayed that this honorable court be graciously pleased to admit the appeal, issue notice to the respondent, and after hearing, pleased to set aside the judgment to the extent of permanent alimony.
My lord, that much.
Your husband,
My lord.
what was the judgment?
The decree, marriage has been dissolved by the finding of the honorable court.
You are,
Decree has been passed in favor of the husband.
and earlier occasion you have filed challenging both.
In fact, I have missed the word to the extent of permanent alimony only. It's a
You are the
typographical,
husband.
it's my mistake, my lord. It's a typographical error which I could not rectify
Alright,
at the time of filing.
It is pre-admission. It is pre-admission.
The wife has also filed an appeal that is on 26th of
That is
2023.
correct.
That has been issued notice and
Amendment allow
again.
you, for considering the request involved within, and as this court find there is genuine request at the instance of the husband, this court allows the IA in the allowing of the amendment, let the corrected a memorandum of appeal be brought on record. Matter be placed for admission after the corrected, after the amended memorandum of appeal is brought on record.
Deeply placed now.
In the meantime, defect number 9 may also be.
It has already been removed.
Already removed. Okay, office to verify on defect number 9 and correct the reporting accordingly. Correct the reporting accordingly on the next date of posting. The Roger is a Puna in Soda, I would recognize the Takada Jauni file.
Hey, please, my lords. My lords, have filed an
So,
IA
this is-
for delay condonation. My lord.
Okay, you have filed an application for condonation of delay.
Yes, my lord. There's a delay of 11 days. my lord.
Delay of 11 days.
Yes, my lord.
And you are?
My lord, I am the
Wife,
applicant, my lord.
wife.
Yes, my lord, wife.
All right, take notice, okay. Issue notice on the question of limitation in IA 285 of 23, requisition is undertaken by Tuesday. Notice be issued fixing short returnable date. Matter be listed for considering condonation of delay aspect. 1 week after the date of appearance expires. Hello. If for convenient of parties, the appellant is also, petitioner is also directed to attach a copy of the memorandum of appeal along with the limitation petition.
God bless, my lords.
For admission item 10.
May I please, your lords? The present petitioner is a wife, my lord. In last occasion, honorable court directed to submit the wages and income certificates and the salary wages, my lord.
Just 1 minute, 1 minute. Last occasion means order date?
Order dated 19/4/2023.
No, we can't, okay, the court has already directed for filing the affidavit in terms of Rajnish Neha.
Yeah.
Okay. Now,
Till
have you
today,
brought the affidavit?
no.
Then
I am filing the affidavit today.
you are filing.
But
You are for the
I am for the
Husband.
respondent.
respondent has brought. Now, this is an application for
Application.
Aji file korchonti. Mr. Tripathi.
nine. No.
Copy it.
Mr. Tripathi, make it sure. It is in terms of the Rajnish versus Neha?
Yes.
No. Judgment ଟା ଦେଖୁନାହାନ୍ତି କାହିଁ ଫାଇଲ କରିଦଉଛନ୍ତି?
My lord, I understand your lordship's query because my lord, if your lordship look at the affidavit, what is
No, will not look unless until it is in terms of Rajnish and Neha. Will not look.
My wife, my lord, is residing with my mother.
What is my lord?
So you will not dated 19/4/23. There is already direction for to the respondent to bring an affidavit on the property disclosures in terms of Rajnish versus Neha and others, 2021 to SCC 324. by the next date. Even though an affidavit has been brought by the respondent in the course of proceeding, this court finds the affidavit is not in terms of
Mutual divorce without any financial
affidavit
claim.
is returned to the counsel for respondent with direction to bring in the affidavit in strict terms of the Rajneesh versus Neha Supra, at least within a period of 10 days.
Well,
This court at the same time also direct the appellant to bring a property statement of the husband.
And also salary wages.
ଆପଣ ବୁଝିବେ ଯାହା ଦବା କଥା ସବୁ ଦେବେ। ହେଲା, property and
2019 no maintenance
financial
will file.
aspect of the husband as per her own information and knowledge also by the next date. Return कर दे रहे।
Present petition
एटा
filed.
कौन पेगा?
My lord, the present petition filed the application, the dissolution of the marriage without giving any.
No, this is an application.
Main dispute, my lord, they without giving any single pie, my lord, the present petitioner.
रुहंतु पुणी आपण से मनोज महाती भलिया दोगिलेनी। The dispute revolves around 13B.
Yes, my lord.
Hela. It was brought by husband.
Yes, ma'am.
Husband.
Present.
Was there any cross appeal or a parallel dispute, cross suit or parallel dispute?
Yes, my lord.
Yes. File करते
I have already present petition, appellant also filed the allegation before the police station, man is threatening and side.
To add to my learned seniors that horizontal velocity also you have to maintain. You have to land at a particular spot.
Yes, ma'am.
13B ସାଙ୍ଗରେ ଆଉ କିଛି proceeding ଥିଲା କି?
No, madam.
ନାହିଁ।
ସେଟା ନାହିଁ କରିବ ନା ଆମେ ଖୋଜା ଖୋଜି
ତାହେଲେ ତା ଦେହରେ ଟିକେ ଆପଣ HM Act ଅଛି କି ଧରିଛନ୍ତି କି HM Act?
No, madam.
ନାହିଁ। କାହିଁକି ଆଉ ଧରିବେ? ଗୋଟେ ବହିଟେ ତାଙ୍କୁ ଦିଅ। ନିଅ। ଏ ନେଇକି ଦିଅ ଆର ବହି କାଢ ଆମ ପାଇଁ। Mr. Tripathi, have you got a book HM Act? ନାହିଁ। ଏଗୁଡାକ ସବୁ argument। ଆଗ 13B ପଢନ୍ତୁ।
Yes. 13B, divorce by the mutual consent. Yes, madam.
The heading is divorce by mutual consent.
Yes, my lord.
So 13B it allow ହେଲା ki?
No. Because that is a very technical case, my lord. Whenever the
judgment decree ଦେଖନ୍ତୁ,
yes,
judgment decree ଟା 13B ରେ ହିଁ ହେଇଛି.
Yes, my lord.
Second capital B.
Yes.
Allow is na reject is. So it's a consented divorce.
By force, my lord. By force. So that is a technical ground.
So did you raise objection to that effect in this proceeding?
Yes, everywhere objector, but that is not allowed. Again,
ଆପଣ original CP ରେ did you file that this has been consent has been obtained by force?
Yes, objection ଟା ଦିଅନ୍ତୁ in the CP
ଆପଣ
proceeding.
ତ objection ହିଁ file କରିନାହାନ୍ତି sir.
my lord,
ଦିଅନ୍ତୁ ଆପଣ objection ଟା ଦିଅନ୍ତୁ CP ରେ.
I have already filed the additional affidavit in by the mother-in-law, my lord, of the appellant.
Not here.
Yes.
CP କଥା ପଚରା ହଉଛି.
CP ରେ ଯୋଉ objection ଦେଇଥିଲେ disputing 13B entertaining. judgment से discuss करते हो ना?
Judgment में page 9.
हाँ?
Page 9 में. Page 9.
Page 9 of this brief.
Yes.
8 रो
judgment.
It starts from page 8.
Okay, forget that. We are not on that even. ये तो decide होगा आपको इटा maintainable होगा ना होगा, that's a different question.
That is
Now
your
question is come to section 25 again. No decision on permanent alimony. Come to section 25. जमा
Yes,
पढ़ा भी
sir.
होऊंगी.
Item 11 that personal.
11.
Personal appearance.
11 रे personal appearance ଅଛି, right, right. अच्छा 11%.
Item 11.
11, Lord.
12 you can go.
And for the respondent.
11, yes.
Yes.
11.
Yes, where is the
My lord.
wife?
I'm for the
Where is the wife?
wife, Lordship, I'm filing.
Please.
Yes. I'm filing this affidavit, Lordship, have I got it?
Joint affidavit is filed?
No, my lord.
Or affidavit?
Sean has been suffered from.
I have filed an individual affidavit.
You have filed.
After due compliance of lordship
You have
direction
filed.
dated 18/7 and 1/8. So also my affidavit of income, asset and liability.
Exam is over, you are filing a false affidavit.
No, Lordship may see, I'm at Bangalore. I'm serving there. My son has been suffered from.
It appears you are playing with the court.
No, no, my lord.
Yes.
That is not my intention, my lord. Lord.
Other affidavit. This is an affidavit shown where?
So, Lordship may see the page. Vidyadhar Mansi.
Vidyadhar Mahanti.
Mansi.
Vidyadhar Mahanti, right. ଏଠି ଆପଣ ସେ ଜାଗାଟାରେ ଲେଖି ନାହାନ୍ତି. Shri Pradosh Kumar Das and Associates were appearing for the wife appellant. Today there is filing of fresh appearance on behalf of Shri Vidyadhar Mahanti by filing a fresh Mokkalagnama also with consent of the Vidyadhar Mahanti, sorry, Mansi. Yes, Mansi. However, with consent of the earlier councils and with the signature of the appellant herein, which is kept on record. It is a separate order of origin. Next, appeal the record. This appeal is had on consent of the parties on merit involved. Appeal involved the following prayers. In the course of hearing, reducing his prayer for the development taken herein through the order sheet of this court dated 30/6/23. Massive, 18/7/23, 1/8/23, then 14/8/23, including one personal interaction appearance of both the parties and the intention of the parties recorded therein. In the order dated 1/8/23, reducing the contest involving the appeal only to the extent of alimony and or compensation, keeping in view the best interest of the minor child, in the best interest, protection of the best interest of the appellant vis-a-vis the minor child herein. Sri Mansingh, in the reduction of his prayer, confining the challenge to the impugned judgment only to the extent of increase in the permanent alimony, while also keeping in view the future interest of both the wife and the child who is also in the custody of the appellant wife herein, brings to the notice of the court through the pleadings herein, particularly through paragraphs capital Roman 3, 4, 5 in the under the heading of grounds. ହେଲା ପରେ ଲେଖିବା ଆମେ ଏଗୁଡାକ ଖାଲି ବର୍ତ୍ତମାନ paragraph ଲେଖିଦବ ପରେ next ଲେଖିବ. It is in the above background also in reference to the affidavit of the, you have served a copy on him, affidavit
Yes,
copy?
Yes, sir.
Yes. In reference to the copy of affidavit at the instance of the husband respondent herein, filed in court dated 28/8/23. 23, sorry. 23/8/23. Date would have checked for you, huh? 23. The husband wherein the husband respondent undertaken in 3 areas of future prospect of both the wife and the child involved herein. Sri Mahanti, Sri Mansingh, look to Sabdela, Sri Mahanti, look to Sabdi Mansingh. Sri Mansingh closed his submission, leaving it for the final outcome of this court. The Patnaik learned counsel, appearing for the husband, in the limited challenge involved herein, also in reference to the order stated so-and-so, and the development taken through the order dated 1/8/23, also in the personal appearance of both the husband and the wife and the husband, and in the involvement of the personal interaction with the wife and husband involved therein, brings to the notice of the court through para 2 that as per the direction of this court through the order dated 1/8/2023, in compliance thereof, the husband respondent has already brought on record by way of memo dated 14/8/23, 2 bank drafts in favor of Shivans Biswal. 3 bank drafts in favor of Shivans Biswal to the tune of rupees 5 lakhs, comma, again 5 lakhs, and 1,50,000 respectively. For the taking this court to the disclosures to the affidavit dated 23/8/23 through para 3, showing the husband's preparedness to come up with a term insurance policy to be opened in the SBI life insurance scheme. In the name of appellant, in the consolidation and strengthening of the future of the minor child involved herein, covering to rupees 50 lakhs with accidental rider of rupees 25 lakhs as accidental death benefit, additional accidental death benefit, and permanent disability rider of rupees 25 lakhs in case of permanent disability taking place in between. We are also taking this court to the undertaking of the husband through paragraph 4 brings to the notice of the court the willingness of the husband through this affidavit in undertaking the entire burden of the deposit oblique remitting the yearly school fees, expenses to study materials prescribed by the institution, and the yearly transportation charges of the minor son for pursuing his studies at Archid International School, Bangalore, up to completion of his elementary education. The Patnaik Learned Council appearing for the husband through the efforts said submits that there has been sufficient protection by way of financial assistance, further also by way of protection of the life through insurance policy, term insurance, life insurance policy, further also by way of depositing the requirements in the education head of the child contents. Court may consider all these aspects and pass appropriate order. Okay, considering the rival contentions of the parties, keeping in view the readings in the Mr. Biswal, taken together with criminal proceeding 272 of 2015. This proceeding was decided on contest of parties by impugned judgment dated 25/9/19, and in the ultimate, there is following direction. Page 5 of the judgment, order portion only. As recorded herein above, next para eguda su para number purito. Wife brought the appeal involved herein. And in the process of argument, the contest of the appeal has been reduced to challenge, confining the challenge to the permanent alimony aspect, while also keeping in view the future interest of the minor child involved in it. This court here find consolidating such our submission, there has been following pleadings. In the factual side, paragraph 4 reads as follows. In the ground side, there is specific pleading on this through Roman capital 4, 5, reads as follows. Roman 3 also. Roman 3, 4 and 5. It be clarified even though Roman 3 also covers provision for maintenance and education. Right. 3, 4 and 5 Roman page internal page 5 and 6 of the impugned judgment. Appeal and memorandum of appeal. Okay. This matter is being heard since (30th 2023). And there has been 4 proceedings at least in the meantime. Proceedings dated 30th/6/23 for better appraisal. The proceedings by order dated 30th/6/23, 18/7/23, 1/8/23, as well as 14/8/23 are all recorded as herein follow. Sabu order would record of. It is keeping in view the aforesaid developments, this court find the elaborate order bringing in some conditions on the husband in the protection of the better future of both the wife and the minor child. The order dated 1/8/23 was passed only after the personal interaction with both the wife as well as husband and examining the mindset of both the parties through the interaction process, further also keeping in view the submissions advanced by both the respective counsels appearing then. Today's proceeding is only a proceeding to attain finality on the issue scrapped in the proceeding dated 1/8/23. Keeping in view the further submissions here, this court find on record there is already a dependent on the order dated 1/8/23, there is already deposit of 3 bank drafts, demand drafts, bearing number so and so, amounting so and so, number so and so, amounting so and so, number so and so, amounting so and so, through memo dated 14/8/2023, it is memo dekhivo. Okay. Dated সঞ্চয় draft approval লাগিয়েছি। This apart, today in the proceeding of hearing, the husband, respondent herein came to file an affidavit, even going beyond the terms set in the order dated 1/8/23, bringing in some further advantages to both the wife and in the better future interest of the minor child involved herein. The undertakings of the husband, respondent herein, through para 2, 3, and 4 reads as follows. Through the above quote kariba na. Ita affidavit date ta hala 23/8. Through the above, this court find there is not only compliance of the direction in the order dated 1/8/23, but through para 3, this court find the husband is making an additional provision by way of term insurance policy in the name of appellant herein, covering accidental rider as well as accidental death benefit and permanent disability rider to the extent 50 lakhs, 25 lakhs, and 25 lakhs extent, respectively. This court observed this is definitely in the better interest of the child involved, minor child involved herein, and appreciate the attempt of the husband ensuring a strong future with the minor child. Okay, it is keeping all the above. This court is satisfied with the endeavor of the husband, and in concluding the appeal, gives the following directions. 1. The husband respondent here, let's say the wife is already in receipt of a sum of rupees 15 lakhs directed by your permanent alimony to be paid to the wife by the judgment of the trial court of the Judge Family Court dated 25th September 2019, sometime in 2019, and must be in enjoyment of this amount and interest, if any, over such amount. This court records this amount is already in the entitlement of the wife, and the wife appellant herein is in use of this amount. Maybe in use of this amount, then Roman 2. Following the development in the course of personal interaction and as recorded in the proceeding dated 1/8/2023, the husband respondent has deposited here 3 drafts amounting rupees so and so, so and so, so and so. Looking to the position of the parties and to avoid any misuse, considering this, all this deposit is meant for protection of the minor child herein. This court feels it appropriate and in the better future interest of the minor child, all these three drafts be returned to the father to utilize all these three drafts by way of fixed deposit in the name of minor child Shivans Biswal, inverted comma of Shiva, with condition to bring the fixed deposit for at least 10 years, long term of 10 years with highest interest yield in a nationalized bank, and with the condition on release of such draft with clear indication in the bank documents, releasing of such amount along with interest will be on the joint signature of the minor child who will be major at the time of trial and the father, the husband hearing. Okay. It had draft condition. Coming to okay, now number 3. A copy of this order. ये जो बैंक रे अच्छी से बैंक रे अकाउंट अच्छी कि पचरले अपन क्लाइंट को जो बैंक रे ड्राफ्ट करछंती okay, it is the responsibility of the say parallel, it is the responsibility of the respondent Sri Samarendra Biswal to bring copy of order of this court, direction of this court to the in the preparation of the fixed deposit to the what is this bank?
Sir, State Bank of India.
State Bank of India.
State
State
Bank-
Bank of India. Okay,
Okay.
very good. State Bank of India.
Boromunda branch, Bhubaneswar. Boromunda branch,
Boromunda branch.
Bhubaneswar.
Hala, for their appropriate preparation of the bank draft along with the conditions stated herein. The preparation of the bank draft be completed within 7 days of the receipt of order, receipt of judgment of this court, and a copy of the fixed deposit along with the terms and conditions in the release of such fixed deposit being supplied by the bank be furnished to the registry of this court within 7 days thereafter by way of affidavit. Then number 3. This court here find apart from the undertakings through para 2 and 3, there is also some amount was given towards education fee of the child already.
Yes, my lord, that I have annexed along with my affidavit, asset and liability, which I have filed earlier.
Today's affidavit.
No, my lord, affidavit in shape of
କୁହନ୍ତୁ କେତେ ଟଙ୍କା କୁହନ୍ତୁ?
1,23,000.
This apart, there is already deposit of 1,23,102.
Yes, my lord, sir. Affidavit page 13 have annexed those
To as contribution towards education expenses of the child to the institution, proof of which is appended as annexure A, capital A, to the affidavit of assets and liabilities of the respondent herein dated 14/8/23. See document.
Amount is being paid below to the institution directly.
Affidavit.
Yes.
Both council have sides.
See if also.
That affidavit is there. Memorandum. 23 7
That is 14-8.
14-8, this is affidavit.
Yes, ma'am.
ଆଉ କିଛି ଅଛି କି ଛଡା?
No, ma'am.
This is all. This is all your remittance?
Yes.
Okay. Okay, there will be, this is in the better interest of the child. So, in the joint affidavit on memorandum of discussion held on 27/7/23 also find place on record. Okay, now go to
There is
next
a
slide.
memorandum of discussion which was held
Actually,
between the parties in
Let
presence.
let
of
us go, everything
Yes,
go in the order, there is
No,
no.
that
confusion.
shows her. What is her, what is her version? That
Yes,
shows, that,
yes.
that memorandum shows that this is the.
Yes.
Okay, next. Through para 3, अच्छा हमें 8 लिखिने तो ये जो term policy कथा तो लिखिने कितना condition गला 1 2 3 हाँ এটা 4 अब. Okay, through the para 3 affidavit dated 23/8, this court record the husband's undertaking to bring a term insurance policy in the name of appellant covering rupees 50 lakhs with accidental rider rupees 25 lakhs as accidental death benefit and permanent disability rider for 25 lakhs in case of permanent disability. This court direct the husband to go ahead with the preparation of term insurance. But will the appellant's signature is necessary?
Required as well as health
Necessary.
condition.
And for there is, and to complete the entire, complete the
Policy.
shopping of the term insurance policy, at least within a period of 1 month. This is, however, subject to wife appellant herein, subject to the respondent sending the necessary form in the with areas of signature of the appellant with sufficient indication of any document required to take support through the application at least within 7 days and 7 days of the judgment, and the wife returning the signed form along with necessary documents to support such shopping of term insurance policy, on receipt of which the appellant, the respondent shall complete all formalities, and on receipt of the term insurance policy shall keep a copy of the Xerox copy of the term insurance policy with him and remit the, अच्छा এটা তো আপনি ডিপোজিট করিবে তাহলে আপন অরিজিনাল তা আমକୁ পঠাই দিଅନ୍ତୁ আপন জেরক্স রখিকি ডিপোজিট করিবে
Every year.
will remit the original term policy insurance to the wife in her address after keeping a Xerox copy of the same for the purpose of with him, for the purpose of making annual deposits regularly, while also sending a copy of the same being part of the affidavit directed already to be filed in this court. That fixed deposit sangre eta bhi apna dei debe. Okay. No, by filing a copy of that by way of another affidavit within 7 days of completion of the or shopping of the term insurance policy. Can এটা আমি 15 দিন কইছু
সেটা delay হইপারে।
সেটা 15 দিনটা সম্ভব নয় পারে।
যাইকে আসলে
ask your client accordingly. ସିଏ ଯଦି ନ ଦବ ତାହେଲେ ତାଙ୍କୁ ଦୋଷ ଦେଇପାରିବେ। ହଁ। ନହେଲେ ଆପଣ ଗୋଟେ କାମ କରିପାରିବେ। You can take leave of this court have a policy in the name of the child.
Directly.
Jadi say she further plays. Okay. Next round lekha. Taking cue from the undertaking of the husband through para 4. This court direct the husband, appellant, the respondent herein as undertaken through the affidavit dated 23/8, of 2023 to go on depositing / remitting, if permissible through RTGS, directly to the institution, the yearly school fees and study material expenses, if any, on a notice being proved, being sent to the notice by the wife, along with the institution's notice on the same, on all such deposits, being sought from the husband, respondent herein at least, and remittance shall be made within 7 days of within 7 days. We say within 7 days. But see, if that is to be deposited by so and so date, then you deposit. Suppose there is expiry by sending, you deposit, you send it RTGS, then she may file an application, deposit has come, therefore you regularize. Within 7 days of, at least within 7 days of receipt of such. The deposit on this side shall be confined only to the school fees and study material required for the, as well as transportation charges required for the education of the child in the school Orchid International School, Bangalore. Urgent need. Okay, next record. This court here find, though there is substantial covering of the protection of the both the wife appellant and the minor child involved herein, this court still find, for there is judicial separation between the parties by way of divorce, and both parties staying at their own places of working. The wife being even though a working lady, earning as per her own statement a sum of rupees 30,000 per month presently. This court feels it appropriate to put a term directing the husband respondent herein to
Respond to the requirement.
to respond to the
Any emergent situation.
wife appellant in any urgent or dire necessity situation, but however, such demand may be placed by the wife with sufficient proof of the same. Suppose medical need ala, tale for that he will also be abided by his commitment so far it relates to meeting with the educational requirement on the higher education of the minor child, if any placed in the future, but however, the future education of the child should be derived on joint discussion of the wife and the husband.
Regarding visiting right and the withdrawal of the two proceeding now pending before the court below. Para 4
Yes.
given those numbers.
With the okay.
ଆପଣ workout କରିଦେଇଥିଲେ ଏଇ ପାରଥାନ୍ତା Mr.
Apart from the above conditions, this court find, for there is complete resolution of the dispute between the parties, there is no necessity of continuance of any other proceeding under any of the law in between the parties involving their marriage dispute shall all stand terminated. All stand terminated, subject to, however, the husband respondent is
Compliance.
complying all above conditions.
On production of the certificate.
The appeal succeed in the with the above directions. No cost before parting with the appeal. This court observed on production of the certified copy of the judgment hearing, the courts involved in all such proceedings shall do well in only declaring the matter to have been closed.
Visiting right. Visiting right out.
Visiting right. Okay, I got a condition that considering out a condition considering the volunteering of the husband in the appropriate future of the minor child even involved herein, and the father being the lawful guardian, one of the lawful guardian, actual guardian, natural guardian of the minor child. Direction, if any, in this judgment shall not be treated to be an obstruction to the father's visit right to the child.
Contract rate as well.
Setup. Subject to subject visiting right to the child or spending some time with the child in vacations, minor child with the vacations. But however, on finding on putting the wife appellant advance notice in this regard and further subject to the vacation arrangement of the child involved here.
Yes.
And if the father wants to visit the child in the school or in the locality
In weekends.
in weekends other than vacation timings, there should not be any obstruction also for the father having the visiting right on the child involved.
Even on his visit to Odisha, because child is coming frequently.
Instead of the place specific no, na?
Yes.
Wherever.
ଶୁଣନ୍ତୁ ଆମେ wife ସାଙ୍ଗରେ କଥାବାର୍ତ୍ତା ହେଇଥିଲୁ ଯାହା she is ready and willing.
She was very much willing.
ଏବଂ willing
She has absolutely no, I mean, there
willing
that.
ବି ଥିଲା accommodating play କିଛି କରୁଛି।
Yes.
ଆସିଛି ଆପଣ ଏଠି ଚିରନ୍ତୁ ଏଇଠି ଚିରିକିରି ଯାଆନ୍ତୁ। That will not see the light of the day even। ଦିଟା କପି କାଲିକି ସୋମବାର ଆଣିବା କହୁଛନ୍ତି ସେ ଜଏନ କରିଯିବେ without claiming। ସୋମବାର ଆଣିବା ଓକେ ମଣ୍ଡେ କରିଦେବା ଆଉ ଆଜି ଆମକୁ ଆଉ ହଇରାଣ ଆମେ ଗୋଟେ କେମିତି ଗୋଟେ କିଛି ଗୁଡ ରିଜଲ୍ୟୁସନ ହବ and we have created something
ପୂଜା ତାଲିଣି ଫାଲିଣି ନଡିଆ ଦେଇକି ଆସିଛନ୍ତି
ଯେତେ ପ୍ରୋସିଡିଂ ହବ ୟା ଛଡା ଯଦି ଆଉ କିଛି ରଖା ହେଇ ପାରିବ ଆଡ କରିବେ।
ସେ ତାଲିଣୀଙ୍କ ନଡିଆ ଟା ତାଙ୍କ ପାଖେ କାମ କଲା ମୋ କ୍ଲାଏଣ୍ଟ କିଛି ଦଉନି ମୋର ହୋଇପାରୁନି।
It's all luck again।
Yes,
Lord Jagannath
Lordship
will
was going
also
to adjourn.
wait here to for him।
Yes,
ଆଉ ଆପଣ ତ ମଣିଷ।
that's right, my lord. Yes, Lordship was going to adjourn and it was a elaborate order.
Modification of.
Pardon,
Call.
pardon. Supplementary list, fresh addition, item 1.
Least here.
My,
Least here.
Item 1.
my lord, it is for restoration, my lord, on 21/12/2022.
There is no limitation.
No, 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 my lord. My lord,
Okay,
my
have you soft copy on Mr. Purohit?
my lord,
Have you soft copy on the counsel for opposite parties?
state ku ଦେଇଛି।
State ଦେଇଦେଲେ ଅନ୍ୟ opposite party ଅଛନ୍ତି ନା ନାହିଁ ଦେଖନ୍ତୁ read petition ରେ ଶ୍ରୀ ଶିଶିର ପୁରୋହିତ,
5,
ଅରୁଣ
6
କୁମାର ଦାସ।
ଆଜ୍ଞା appear କରିଥିଲେ କିନ୍ତୁ କାଉଣ୍ଟର ଫାଇଲ କରିନଥିଲେ। ସେଗୁଡା ବି ସେ ନଥିଲେ।
କପି ଦେବେନି ନହେଲେ notice ଯିବ ନା you are unnecessarily delaying।
ଯାହା କରିବ ହଜୁର ଆଉ।
notice ପଠେଇଦବା।
ଆପଣ ଯଦି ଚାହିଁବେ କରିଦେବେ ଖାଲି
ନାଇଁ ନାଇଁ ମୁଁ ଚାହିଁଲେ ସେମିତି ହବନି।
ମୋ ଦେହଟା ଖରାପ ଆଜ୍ଞା ହେଇଗଲା
ନାଇଁ
ସେଦିନ।
ନାଇଁ ଆମେ ପୁରା ନୀତି ନିୟମ ନିର୍ଦ୍ଧାରଣ କରୁଛୁ ଅମୁକ ୟାକୁ
ନାଇଁ, ନାଇଁ,
ଅମୁକ ୟା କରିବୁ
ନାଇଁ।
ମୁଁ ଗୋଟେ କିନ୍ତୁ
ଆଜି
କିଛି କାମଟେ କରିବି। ଆପଣ କପି ଦେବେ କି କାହାକୁ?
ନାଇଁ ଆଜ୍ଞା ନୋଟିସ ସେ ନେବେ କି ନ ନେବେ କଣ କରିବେ ଫେରେ।
Okay, all right, issue notice in the matter of same appeal, ହେଲା। Considering there is already appearance in the read petition on behalf of OP number 4 and 5. Well, notice requisites be filed notice only on opposite party number 4 and 5. Extra copy be served by way of notice on OP number 1 to 3. Needs. Matter be placed immediately after.
By registered
notice
post.
is served.
Registered post registered post है।
Speed post.
ना speed
Registered
registered
post or speed post.
हाँ हाँ
ଦିଟା କରିଛି ଯୋଉଥିରେ ଚାହୁଁଛନ୍ତି।
ଆଜ୍ଞା ଆଜ୍ଞା।
Item number 2.
My opinion, not. My lord, in this case, the petition purchased the case land by the registered study annexure 1.
Okay, your allegation, the
Allegation not entertained, my lord.
Not-
Kହୁଥିଲି 2013,
entertained.
my lord,
not entertained.
my lord.
ଯେ ଆଜିକାଲି ଆଉ entertain କଣ କରିବାର କିଛି ଅଛି ସେ ତ ଆପଣ ପୁରା ହବ ଇ ଫାଇଲିଂ।
ସେ ନୂଆ କବଲାଟା ଇ ଫାଇଲିଂ ରେ ହଉଛି, ଏଟା ପୁରୁଣା କବଲା ଅଛି ବୋଲି ଏଣ୍ଟରଟେନ୍ କରୁନାହାନ୍ତି।
There is allegation. ନୂଆ ଏଇଟା ପୁରୁଣା କବଲା।
My lord,
ପୁରୁଣା କବଲା ହେଲେ କଣ ଇ ଫାଇଲିଂ ହେଇପାରିବନି?
ନା ହଉନି, ନା ବହୁତ ଚେଷ୍ଟା କରାହବାରୁ ଲୋକ ଆସିଲେ ହାଇକୋର୍ଟକୁ।
Okay. Mahapata counsel appearing for the petitioner brings to the Hon'Ble the notice of the court that for the old sale deed involved herein, there is no possibility of e-filing. Further, even on extension of hard copy to the Tahsildar Ali, AUL, the Tahsildar Ali is not registering the proceeding. Annexure 3 is the proceeding.
The mutation petition ଟା ଆମର mutation petition my lord.
Annexure 3 is the proceeding. You have filed Annexure 3, there is some process. Case record is put up today. Record keeper has verified ROR.
ସେଇଟା my lord, ସେ ଯୋଉ ଲୋକ ସାର୍ ଫାଇଲ କରିଛି ମୋର ସେ ଭୁଲ ଏଇଟା ଫାଇଲ କରିଛି, ଏଇଟା ହଉଛି ତା ପରଟା ହଉଛି ଆମର mutation application. ସେଟା ମୁଁ ଦେଖୁଥିଲି wrongly ପଶି ଯାଇଛି ଜେରକ୍ସ ରେ। ସେଟା not case land.
wrongly ପଶିଗଲା।
My lord, that's not case land.
ତାହେଲେ ଏଇଟା withdraw କରିଦିଅନ୍ତୁ, ଭଲ ଜିନିଷ ଆଣନ୍ତୁ।
ଖାଲି annexure 3 ଟା entertain ହବ ଆଉ କଣ?
Annexure 3 ଟା ପୁରା it's already a proceeding undertaken. So ଯଦି କହିବେ Annexure 3 ଟା disposal target disposal କରିଦବା। ଆପଣଙ୍କ ଉଦ୍ଦେଶ୍ୟ କିନ୍ତୁ ସେୟା ନଥିବ ଏଥିରେ।
ନାଇଁ ଆମେ ଯୋଉ ପ୍ଲଟ ଟା କରିଛୁ my lord, can you see?
Document permitted to withdraw in order to bring a accurate writ application. ହେଲା, yes. Yes, next.
Item number 3.
My lordship, conveyance
Yes,
for
sir.
Jali, my lord.
Fresh admission.
My lord. Paying for a direction to dispose my revision petition, my lord. Pending before the OP number 5, my lord.
So ସେଠି admission ହେଲାଣି ନା ନାହିଁ?
No, my lord. Praying
ଏଇ
for
ତ fresh admission ରେ ଯିବ ଆଉ ଠିକ ଅଛି।
sub item also same.
Item 4.
But annexure 4 is under challenge. My mutation has been mutation petition has been rejected on the ground that will is not probated. It is unprobated will. Therefore,
which area?
both.
Both ର judgment କାହିଁ?
ଅଛି। your lordship's judgment.
It's the only ground available in the challenge of the mutation, order in the mutation case number 52 of 21. Appears to be a refusal of the mutation proceeding on the premises of no probate of the will involved therein. And dependent on the observations in the communication dated 7/5/2018. This court involved the submission of party in contest. For the submission of SAHOO, further is disposal of the mutation proceeding dependent on the direction contained in the communication dated 7/5/2018. No fault may be found with the mutation authority in dismissing the matter. There is, however, no dispute that both since a partition district carved out from the original district Fulbani, there is no need of probate of will in the district of Fulbani. এটা ଆପଣ କେଉଁଝରରୁ ଆଣିଛନ୍ତି?
କେଉଁଝର କିନ୍ତୁ ସେଥିରେ
ୟା ଦେହରେ ବହୁତ ଅଛି।
ହଁ ବହୁତ ଅଛି। ମାନେ ସ୍ପେଶାଲ ଓଡିଶା ଯୋଉ ଆଡମିନିଷ୍ଟ୍ରେସନ ଅଫ ଓଡିଶା ଷ୍ଟେଟ୍ସ ଅର୍ଡର 48
ବହୁତ district
free ଅଛି ଓଡିଶା।
There is a long drawn order under the heading of Administration of Orissa States Order 1948. Perusal of provision 4, order 4 and order 5 therein. Both district is also already stood covered in getting the exemption from probate of will. It is keeping this in view further application of judgment of this court through 2022/2 OLR 1030. Also decided, keeping in view similar subject, this court find the petitioner has a case made out requiring interfering in the order at an SO4. This court therefore interferes in the final outcome in the order 4 dated 23/6/21. Set aside the same, remit the matter back to the Tahsildar.
Additional Tahsildar
Harbanga for undertaking the fresh exercise in and giving a lawful disposal without insisting probate of will involved therein.
Both district decide
Both district decide ହେଇଛି ଦଉନାହାନ୍ତି ସେ କିନ୍ତୁ ଏଠି both district ମଧ୍ୟ ଦେବେ ମୁଁ କରିଦେବି ଦେବେ ମତେ ଦେଇଦେବେ ସେ ସେଇଟା ବି କରିଦେବେ ବଟ୍ ଏଇ କେସ୍ ରେ ବି ମୁଁ ନେଇଛି ସେ ଅର୍ଡର ଟାକୁ ଡିସ୍କସନ କରିଛି ସେ ଅର୍ଡର 5 ରେ ଅଛି ଏଗୁଡାକ ସବୁ ଅଛି ଆଠଗଡ ଆଠମଲ୍ଲିକ ବମରା ବରମ୍ବା ବଣାଇ ବୌଦ୍ଧ
ଆଜ୍ଞା ଏଥିରେ ଅଛି
ଜଜମେଣ୍ଟ
ମାଇନର ଅନଡିଭାଇଡେଡ ଫୁଲବାଣୀ ହେଲେ ବି ବହୁତଟା ସେଥିରେ ଅଛି
ଆଉ ଦେଖିବେ ନା ଆଉ ଆପଣ ତ
ଏଟା ସ୍ପେସିଫିକ ବୌଦ୍ଧ ଡିଷ୍ଟ୍ରିକ୍ଟ
ହଁ ବୌଦ୍ଧର ଯଦି ହେଇଛି ଆପଣ କଣ ସେଇଠି ମେସିନ ପ୍ରିଣ୍ଟର ରଖିଲେଣି Okay, further also through the judgment in WPC 32009 of 22 specifically dealing with both disputes. देखिए आउ टिके सर्च करिवे ना प्राय मोर सब डिस्ट्रिक्ट रे मु देई दीची आ सेई भितरे जेतिकी अछि सब गुडा को कवर and I have taken a decision of the Supreme Court. Supreme Court said for mutation purpose probate is not necessary. So that decision in a greater way helped the parties. That decision says once a party is interested to create third party interest, then unless you clear the stamp on that, then a probate न कले आपनकर stamp clear होउनी स्टाम्प क्लियर नहले अन्य डिस्ट्रिक्ट पई सेटा स्टाम्प क्लियर नहले सेटा आपनकर फर्दर सेल को जाई परिबनी हियर स्टेट इज द ऑर्नर तार गोटे स्टाम्प भी पळेबो ସେଥିପାଇଁ ସେଇଟା ଅନ୍ୟ district ରେ ବି help କରିବ ଏଇଟା କେବଳ ବହୁତ ବି help କରୁଛି ନୁହଁ ସବୁ district କୁ help କରିବ that original judgment. Right, 5.
Item 5.
My lord, pardon my lord. Sub-register भी पठेइଥିଲେ से annexure 3 टा एटा तहसीलदार एंटरटेन करनांती.
Sorry. Yes, next.
Item 5.
Next.
सेतर भी नंबर नहीं. My prayer to entertain
ଆଉ
नहीं.
ଆସନ୍ତୁନି ଛାଡ଼ନ୍ତୁ ଯାଆନ୍ତୁ. Yes, next.
Investor poor man my lord entertain खाली
Yes,
करिवे
yes,
disposal
right.
करिवे.
Yes.
Next. Yes, item 5 with the
Yes,
council.
item. Sir, କହୁଥିଲେ.
ଆରେ ସିଏ ତାଙ୍କର ଛିଡା ହେବେ ତାଙ୍କର କେସ୍ ସରିଲା ମନା କଲି ପରା ମୁଁ ଆଉ
Yes, my lord.
ସେଟା
ପ୍ଲିଜ
I am challenging.
ସଡ଼ଙ୍ଗୀ ପ୍ଲିଜ
ସେ जो order ଟା ହେଇଛି ସେଟା ଆମେ
ପ୍ଲିଜ ଆଇ ହାଭ୍ ଅଣ୍ଡରଷ୍ଟୁଡ ଆପଣଙ୍କର ପୁରା ଫଣ୍ଡାମେଣ୍ଟାଲି ରଙ୍ଗ ହେଇକି କୋର୍ଟକୁ ଆସିଥିଲେ
ନମ୍ବର ନାହିଁ ସେଥିରେ ବି.
ପ୍ଲିଜ ଡୋଣ୍ଟ ୱେଷ୍ଟ ମାଇ ଟାଇମ. Yes.
Yes, my lord. I am challenging the order of Lokayat of Odisha. The disciplinary proceeding.
Where is
against-
certified copy of Hanesu 1?
Yes, sir. I have
ଅଛି file ହେଇଛି.
filed
Yes, what is the challenge?
disciplinary proceeding against me.
How are you agreed by this order?
Sir, in the Phonni cyclone,
How to mic ତଳକୁ
in the Phonni cyclone, government has declared to a scheme to give the house assistance for 95,100 rupees for severe damaged houses. But one of the petitioner, one of the complaint who is the Devras Ponda,
what is your ground, right? There has been penalty imposed on you.
sir, I am the only
You are Vikas Jana.
1 minute, sir. I am the Grammar Rojogar Sevaka. My
yes.
duty is, sir, only to identify the houses of the village, nothing else. So,
ତାହେଲେ କଲେନି ଆପଣ ତା ହାଉସ କାଇଁ ଆଇଡେଣ୍ଟିଫାଇ କଲେନି?
no,
You have a role in the public domain. ଆପଣ ଆଇଡେଣ୍ଟିଫାଇ କଲେ ତାଙ୍କୁ ଟଙ୍କା ମିଳିବ. ସେ ପଇସା ଦେଲେନି ଆପଣ ତାକୁ ଆଇଡେଣ୍ଟିଫାଇ କଲେନି. There is an inquiry report.
identify ହେଇଥିଲା କିନ୍ତୁ sir ମୁଁ ହଉଛି ତା ଦେହରେ 16 numbers in ଇଏ ସେମାନେ 16 numbers of beneficiary are 16%, but 9% are illegally taken the money.
What is the ultimate direction? ଆପଣ ଟଙ୍କା ଦେବେ
ଆଜ୍ଞା
ନା ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଟଙ୍କା ଦବ ଆପଣଙ୍କୁ ରିଏଲାଇଜ କରାହବ?
sir ମୋର ତ ସେଥିରେ କିଛି ରୋଲ ନାହିଁ, ମୁଁ କେବଳ ଖାଲି ଗାଁକୁ ଯିବି ଆଇଡେଣ୍ଟିଫିକେସନ କରିବି କାହା କାହା ଘର ଭାଙ୍ଗିଛି ବୋଲି.
You have been allowed to participate in the proceeding or not?
Participate
କରିଛନ୍ତି.
Yes, sir.
So your objection has been considered. ଆପଣ ରିପ୍ଲାଇ ସବୁ ଫାଇଲ କରିଛନ୍ତି.
ଆଜ୍ଞା
ଆଉ କଣ ଗ୍ରାଉଣ୍ଡ ଅଛି? There is no ground.
ସେ ଗ୍ରାଉଣ୍ଡ sir
Your role may be limited, but you have a role.
sir
You don't say that you don't have any role. You say my role
I
is
have
limited.
my role is only to identify the
So
person,
you have a
nothing
limited
else.
role. Even all such persons involved here have been penalized. Ineligible ଲୋକଙ୍କୁ ଆପଣ ଆଇଡେଣ୍ଟିଫାଇ କରି ଟଙ୍କା ଦିଆହେଇଛି. So there is a right consideration. କଣ କରାଯିବ?
ନାଇଁ sir ମୁଁ ତ sir only identify କରୁଛି ମୋର sir ମୁଁ daily labor ର ସେଠି କାମ କରେ, ମୋର ତ daily labor ରେ ପଇସା ମିଳେ କିନ୍ତୁ ମୁଁ
ମିଳେ ସେଥିପାଇଁ ଆପଣ ଅନ୍ୟ ଉପାୟରେ ପଇସା ଆଦାୟ
ନାଇଁ
କରୁଛନ୍ତି.
sir ମୁଁ ପଇସା ନେଇନି, ଗଭର୍ଣ୍ଣମେଣ୍ଟ ତାଙ୍କର ଇଏ
But it is established here.
That
There has been
during that
ineligible
verification
persons in
process-
benefit. ଆଉ ineligible person କୁ benefit ଆଣିବାରେ ଆପଣଙ୍କର ଉତ୍ତରଦାୟିତ୍ୱ ଥିଲା.
ନା ଭେରିଫିକେସନ sir ଫାଇନାଲ ଭେରିଫିକେସନ ମୁଁ କରିନି, ସେମାନେ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଯୋଉମାନଙ୍କୁ ତାର କମିଟିରେ ରଖିଲେ ସେମାନେ କଲେ, ମୁଁ କେବଳ ଗାଁକୁ ଗଲି ଏଇ ଲୋକଙ୍କ ଘର ଭାଙ୍ଗିଛି ସେତିକି ଖାଲି ଦେଖେଇଲି, ଆଉ କିଛି ନାହିଁ.
What is your
ଫାଇନାଲ ଅର୍ଡର ତ sir
what is
କମିଟି
your other ground? Any other ground you have?
similar order has been passed by this
ହଁ,
court.
ସେଇଟା କଣ କାହା କେସ ରେ ହେଇଛି?
ଏଇ କେସ ରେ ହେଇଛି
ଏଇ କେସ ରେ କାହାର କେସ ରେ?
sir OP number
ହଁ ସେଇଟା ଆର୍ଗୁ କରନ୍ତୁ.
OP number 8 OP number 8
ଇଞ୍ଜିନିୟର ର କେସ କୁ ଆପଣ ଆଡମିଟ କରିଛନ୍ତି?
Yes.
ତେଣୁ ମୁଁ ବିଚାରା କରିବ ମୋ କେସ୍
ଆଜ୍ଞା OP number 8
ସେୟା କହୁନାହାନ୍ତି ଏଇଆ କରିଦବ ବୁଝିଲ ଏଇଠି ଅଛି ଓକେ notice issue over, no question, but that should have been your first round.
Yes.
ବଡ ବଡ ଅଫିସର କୁ ନୋଟିସ କରାହେଇଛି ଆପଣ ଜଣେ ସାମାନ୍ୟ କର୍ମଚାରୀ ତେଣୁ ତା ସାଙ୍ଗରେ ମିଶିକି କରାଯାଉ matter to appear in final hearing allow me so ବୋଲି କରିବେ yes
Obliged. Item 6.
may I please your honor covered covered ki Mr. Mishra
Lordship, Lords, the prayer is against the municipal corporation.
कौन से order
Enhancement of license fees. The prayer is against the municipal corporation, Lordship.
Room rent has been extended, revised. Room rent has been, representation has been filed for consideration, which has been disposed of by your lordship on
एटी
70th.
ଅଛି ଏଠି ଆପଣଙ୍କ representation pending ଅଛି
Yes, ma'am. Annexure 3. ma'am.
representation by way of objection
Yes, my lord.
annexure 3
My lord.
all right same line
Obliged.
ଏଇଟା ଦିଟା କେସ୍ ଅଛି
My lord, sub item also same.
ସବୁ ପୂଜା କମିଟି ବର୍ତ୍ତମାନ କୋର୍ଟରେ
No, Puja committee actually they are shop tenanted shop owners.
Item 7.
7, my lord. This is for application of the mutation of the plot that has been dropped. My lords may see page
page
35, annexure 7 and annexure 8. In a very callous and mechanical manner, they have dropped the case, my lords, without granting any opportunity of hearing. My lords.
it's not it's finally concluded
Dropped, my lords, and if my lords may see the dates also. 1/7/2022 रे direction करले RI direction करले ARI को field inquiry करेगा to prepare sketch map. Then again on the same date took up the case and held that despite repeated adjournments, no documents could be produced. There is no occasion granted to the petitioner to submit any documents.
then
So, my lords,
next page is
next
another
page another
proceeding.
e-file mutation, my lords.
then
But that also, my lords, in that
what is
manner.
annexure 8 then
Both, my lords, annexure 7 and 8 both are the orders.
yeah how can you put both these impugned orders in one petition
Same case, my lord. Same plot.
no,
my lords.
not same case it is 19315 that is
Same case means, my
3269.
lords, in respect of the same mutation of the same plot, my lords.
No, no.
Since it was
Same
dropped,
plot ରେ
again he
ଦିଟା
filed.
mutation କାହିଁକି ଆସିବ
CA, my lords,
ତାର
there is-
subplot ହେଇଥିବ
subplot ନୁହେଁ ସେଟା ଥରେ reject ହେଇଗଲା ତ he again with hope that he may get mutated his land, so he again filed an application. He also filed for a third time that I have annexure 9, my lords, that is pending. My lord, it would suffice if my lords may direct the Tahsildar to consider and properly adjudicate the mutation case by considering and granting opportunity to the petitioner.
so second case how can there be two cases Mr. Mishra
Bar, there is no bar.
yes there are two cases on khata number same khata number and plot
Lordship,
number
that is same. However, Lordship, when at page number 35, in that land schedule,
35 is definitely illegal 17 he sends for report
Lordship.
and on the same date he drops the proceeding
My lord.
so that is prima facie appearing illegal see first order 1722
Lordship, I have that order.
issued individual notices to the vendor so and so direction to remain present in my office on 17 ର order ରେ 17 ରେ ସେ ଆସିବ କେମିତି
Pura mas that.
again 17 is and ARI is ARI is directed to submit the field inquiry on 17 ଏଗୁଡା ସବୁ dash ରହୁଛି ବୋଧେ ତା ଦେହରେ ସେ ତାରିଖ ପକେଇ ଦେଇ
My
ଚାଲିଗଲା
lord, that they are doing. Mechanical manner they are disposing and dropping.
so this order will definitely go but I find surprise simultaneously there is parallel order on same land in another proceeding how it is possible Mr. Mahanti,
subsequent dates
what
रे
is
से
the
आ-
second
he-
case? Who has filed that case?
same person मतलब same petitioner
Now, how can how there is possibility of two cases?
मतलब 2 case मतलब annexure 9 टा देखिए annexure 9 टा pending ଅଛି he again took a chance and his mutation case
Because
is
instead of
pending.
filing repeated cases, the better would be to go for appeal.
No, not appeal.
Nahin.
Case has not
Because
been
it's
decided
the
on
second
merit.
case, it is hit by res judicata, your lordship,
Annexure
by the first
7,
order.
there is no need of appeal.
No need मतलब
Prima facie is satisfied.
Lordship.
obligation.
But even then, annexure 8 is still there.
So 8 is a reasoned order.
Lordship.
So 8 he may prefer appeal. But I find why there should be multiple mutation cases on same land. See, page 35, the bracketed portion. Khata number 474 by 71. Next page, see 474 by 71. Then see plot number 516 1762, 516 1762. Then area 1000 in acres or 1 acre.
1 acre.
Area 1 acre. केवल area in hectares रे difference अछि. That's a different thing. किसान भी बाजे फसल. How there is possibility of two mutation cases?
Should be hit by res judicata, lordship.
So you take instruction.
I'll
I
take
am not
instruction.
interfering in the order set now.
Lordship.
This court find the repetition involved challenge to order at annexure 7 as well as annexure 8. Even though reading of the order dated 1/7/22, both orders dated 1/7/22 involving mutation case 1931 of 22, 19315 of 22, by annexure 7 appears to be prima facie erroneous order, as there is no possibility of second order in view of the directions contained in first 1/7/22 order. It is at the same time this court find there has been drawing of another mutation case on the self-same land schedule and decided by annexure 8. This court direct service of 2 extra copies on the state council, who is directed to take instruction as to where is the possibility. ଆପଣ ସେଥିରେ ବି ଦେଖନ୍ତୁ ସେ order ଗୁଡାକରେ ବି ସେଇ ପାର୍ଟି ଶ୍ୟାମସୁନ୍ଦର ଅଗ୍ରୱାଲ if as to what is the reason of institution of two mutation cases in the involved party is common and property is also common. Place this matter next Friday. So,
Lordship.
Next Friday.
Well,
Please. Item 8. Next Friday will be first.
First.
Yes.
Well, item 8, acceptance of form 2. Form 2 under that regulation.
ଆହୁରି ଚାଲିଛି ରେଗୁଲେସନ ଟୁ
ସେପଟ ଏରିଆରୁ ସରିବନି।
ଏଥିରେ ଆପଣ କାହିଁ ଆସୁଛନ୍ତି?
ନାହିଁ ଆଜି
ପିଲାମାନେ ଆହୁରି ଜଟିଳ ମାମଲାରେ ଅଛନ୍ତି।
ସେ ସିଭିଲ କୋର୍ଟରେ ଏଠି।
9
may I please? Direction given to the
Item 9.
Direction given to the opposite panel to not to implement the order of passed by the.
How can there be such a direction?
Your lordship, you kindly see annexure 6, my lord. Annexure 6, your lordship.
Annexure
6, my lord.
6.
Yes, your lordship direction given.
Page कौन?
Page 19, my lord.
Page
19.
Page, sorry. Page
I'll tell you,
42.
page 42.
42.
Yes.
Direction है लाचे implementation करिया अपने।
पढ़ो तो।
Disposal of the read petition, this court directed the competent authority to bring out the.
Your voice is going down. Please be on mic.
Yes. In disposal of the read petition, the court directs the competent authority to bring out the appropriate record of it in terms of annexure 2, but while also keeping in view of the observation herein above, the entire exercise be completed at least within a period of 1.5 months from the date of the communication of the order.
So,
that application, that was civil suit is pending before.
Civil suit is pending,
Yes,
right?
yes.
But it is a preparation of record of right or not?
Yes, I am challenging that order before this honorable court. My kindly see first petition against that order, my lord.
Yes.
Your lordship direction given to the me to file the appropriate forum, my lord. In annexure 2, my lord. Annexure 2. Page 17.
Other repetition was dismissed because earlier a repetition was already disposed of.
Yes, yes. ସେଟା ମୋର ଗୋଟେ share ଅଛି ନା ସେ
No, now come to the point. Your submission that in spite of a revisional court order, there is also pendency of a civil suit. So record, if any, will be prepared, that will be subject to outcome of the civil suit.
Yes.
Ultimately, the civil court direction will prevail over 15B order.
Yes.
So with that observation, I am disposing at the submission of my counsel for the petitioner undisputedly. And as disclosed in the pleadings in the writ application, there appears there is pendency of civil suit. कौन से suit or number?
Civil suit होची annex
civil suit 485 of 22 pending before civil judge.
ସେଥିରେ ସେ appeal କରିଛନ୍ତି objection ଦେଇଛନ୍ତି.
It is keeping in view this development. This court in the disposal of writ application observes in the event the direction in Annex 1 in the disposal of RP 189 of 2019, an application under section 15B of the OSS Act 1958 is prepared. Same should be subject to ultimate outcome in the civil suit number so and so. With this observation, the revision
application expiry order pass କରିଦେଲେ ସେଇ order ଟା ମୁଁ challenge କରିଥିଲି.
Ultimately civil court order এটা revision
ସେଇଟା ସେ କଣ କହୁଛନ୍ତି ଆମକୁ
37 ରେ revision ନୁହଁ ସେଟା କିମ୍ବା 32 ରେ ବି ନୁହଁ ଯେ these are competent civil revenue authorities. It is merely 15B order. Therefore it is ultimately bound by
order ପଳେଇଛି ତଳେ ସେ କହୁଛନ୍ତି ଆମେ ଇ କରି carry out କରିଦେବୁ civil case pending ଅଛି
carry out କରିବେ but ସେଠି endorsement ଟା ବର୍ତ୍ତମାନ ଦେବେ. This is however subject to outcome.
Item 10.
May please your lordship.
ଆପଣ ଏଇ କାଗଜ ପତ୍ର ସଜଡାରେ କାଇଁ ମାତିଛନ୍ତି? ଆପଣ ଯାଇ ସେଠି ଇଞ୍ଜେକ୍ସନ କରୁନାହାନ୍ତି?
ଇଞ୍ଜେକ୍ସନ ଫାଇଲ ହେଇଛି
କରିଛନ୍ତି ଫାଇଲ କରିଛନ୍ତି
already file objection file କରିଛନ୍ତି sir.
ଇଞ୍ଜେକ୍ସନ ହେଇଛି କି?
ଇଞ୍ଜେକ୍ସନ notice ଦେଇଥିଲା objection file କରିଛନ୍ତି.
ଇଞ୍ଜେକ୍ସନ କରୁନାହାନ୍ତି ସେ ତାର କାଗଜ ଧରିକି ବସିଥିବ ଆପଣ ପ୍ରପର୍ଟି ରାଇଟ ଧରି ବସିଥିବେ.
ସେ କହୁଛନ୍ତି ସିଭିଲ କୋର୍ଟ ଅର୍ଡର ଆମେ ମାନିବୁନି ହାଇ କୋର୍ଟ ଅର୍ଡର ଆସିବା ମୁଁ କରିବା ପାଇଁ 1.5 ମାସ.
Whenever possible. Yes, next case.
Settlement authority not accepting my application, lordship. Not accepting.
Not accepting.
Lordship.
What application not being accepted?
12 application.
Okay, all right. Page 53, there is order covering.
36. Page 36. Page 36 रे जो order टा ଅଛି सेटा cover करियो आपनकर.
36.
हां हां.
नै मैं धरछि 27641.
41. Yes.
आपन बैच केस अछि तो सेतरे 56 रे अछि. 53.
Let's.
For orders item 11.
Company.
Again.
My lord, in this case, on the last occasion, your lordship directed me to give the paper cut piece in its original. I have failed in my duty. Your lordship may grant me 1 week time. I have collected, but I have not prepared that affidavit.
So you bring it by Monday.
Monday.
That is
Monday or Tuesday.
That is in relation to which IA?
7. My lord, 7 of that is. Okay. 7 of IA 7 of
IA 7 of 23. This court record the statement of Sri Biswanath Rath, learned counsel appearing for the PF organization, undertaking to bring an affidavit in the enclosure of the paper publications.
In original.
Paper publications in original, bringing in the advertisement. In original, let him file the affidavit by Friday at least, by Monday. By Monday.
Can it be Tuesday?
Okay, by Tuesday. Yes, so what else? What other issues?
Lordship, I have filed a report today that may kindly be accepted.
So 7, there is no further order.
I know, Lordship, that was their contention. One contention was done away by this Hon'Ble Court. That is, they are not eligible to get any 7Q. That is as it passed already. The only thing they were supposed to file that publication which my lord has already
So
noted.
therefore that
Nothing is
process-
required from my side, lordship.
Okay.
And two, three things.
Mr. Das, then 723 will be kept pending.
Your lordship, on the last occasion, initially observed that there is no point in keeping this 7 up
Okay,
to
all right,
10.
that is closed already.
Thereafter, your lordship said,
All right, all right.
since other matters are there, let it be pending.
Okay, all right. Then you are in which miss case? You are in which miss case?
Lordship, me.
Hmm.
Lordship, the first thing is this is lordship, 1 of 2023, miss case 1 of 2023.
1 of 23.
Lordship.
Okay, it is at flag. No, it has to be
Flag 19, lordship.
ଆଚ୍ଛା ଏପଟେ ଦିଅ ତ ଆଣିବ ଗୋଟେ 15 କିଲୋ ଫାଇଲ ଥୋଇଲେଣି କାହାନ୍ତି ପିଲା କୁଆଡେ ଗଲେ? ଏଠି ଖାଲି ସେ ଲାଷ୍ଟ ଅର୍ଡରଟା ଖାଲି ଲାଷ୍ଟ ଅର୍ଡରଟା କାଢିକି Yes, Mr. Sekhar, what is your submission?
Lordship.
1 of 23 involves what relief?
This is lordship with regard to my adjudication of one unsecured creditor, that is Cotton Corporation of India. Now they have claimed that I have not given them 74 lakhs rupees, which was a check bounce case. And
previously it was there. Lordship, before the closure of the OTM.
So how can that be taken care of in Company Act proceeding?
Yes, before the Company Act proceeding, it was filed and my application was pending.
You might have brought a litigation. Is it entertainable? It is pre closure of the industry. We are the Company Act proceeding only dealing with the post closure.
May I, my lord? May I assist, my lord? They were one of the unsecured creditors as per the last balance sheet. So their claim to a tune of rupees 5.22 crores approx was admitted.
Right.
Now they said that there is some more claim that is of amount of 74.42 lakhs.
There is adjudication on 5 crore and odd. By which order?
This is my order, my lord, because adjudication, I am the adjudicating authority for
You have
unsecured.
passed the
I passed the order.
Is it forming part here?
Yes, lordship. It is part of their IA, lordship.
Then which page? Which is that impugned order?
Lordship, at page.
What is the position in the release, Mr. Sekhar? What is the position?
Lordship, we are
in the release of the dues of unsecured creditor.
Unsecured, we had 30 numbers of total unsecured creditors. We have issued dividends to all the creditors. Until date, 18 people, they have returned their dividends.
Admitted dues you have given.
Lordship.
Consequently, he has also received 5 crores.
Lordship. No, he has not received because he has challenged my order first. So I said, let the Honorable Court decide first, then I can release
He is
the.
already in entitlement
Yes,
of 5 crores.
we are in possession of that money, my lordship.
So no, नहीं जाना कहीं की
Lordship.
5 crores से तो determine कर सालेनी अपन नहीं जाना कहीं की.
That will take we have the bounce check which was the case was pending.
That's a different issue.
After that they have considered it. That lordship report is there.
My report is
Now
that
74 lakhs is disputed.
No, that now it is cleared by the
lordship.
You don't press this.
Lordship.
Then you don't press this. There is no adjudication necessary if he has decided to pay that 74.
Lordship.
You have decided to
Yes,
pay.
Lordship, I have filed a report at flag Z, my
Flag
lord.
Z, Lordship.
Okay, all
Flag
right.
Z.
Okay, bring to that portion only. Which para?
Lordship, para 4 and page 2, para 4 and para 5, my lord.
Yeah.
Para 4 and 5.
Para 4 is important, Lordship.
Please read. Read.
Lordship, that in this connection, it may be stated that the chartered accountant appointed for the settlement of claims of creditors.
1
Very-
minute, one minute. Para 4 you are reading.
Lordship, para 4, page 2.
The copy you have supplied, right?
Yes,
now?
Lordship, flag Z, it is listed, Lordship.
Flag Z.
No.
Z, Lordship.
Well, chana diyo. Legal assistant to document.
For settlement of claims of creditors verified the documents and informed by email dated 3rd August 23 that the assumption which was taken earlier was made due to non-availability of documentary evidence relating to supply and delivery of cotton, nor the proof of dishonor of check at the time of submission of their claim to substantiate the claim of rupees 74.42 lakhs. Now the documents have been received and hence the said rejected amount of rupees 7.
Then there is no dispute, just release. I am.
Yes, Lordship.
How much time you want?
One day I can raise, Lordship. If he agrees, my lord orders, I'll raise in one day, Lordship.
All right, Lekha.
Only my prayer will be that 74 lakhs with the interest only. Nothing.
No, Lordship. We cannot pay the interest, Lordship. There is no provision, Lordship.
ଏଠି ଆପଣ ସେଲ୍ ପ୍ରୋସିଡ୍ ଆମେ ଡିସଚାର୍ଜ କରୁଛୁ ଏଠି କିଛି ଏଠି ଗଜରିବାରେ ନାହିଁ ସୁଧ କି ଆଉ ଆଡିସନାଲ ଇନକମ୍ ନାହିଁ କେମିତି ଆମ ଦୋକାନ ବନ୍ଦ କରିବୁ ଆମେ ଚିନ୍ତା
Company has continuing due to me.
ସେଣ୍ଟ୍ରାଲ ଗଭର୍ଣ୍ଣମେଣ୍ଟ କୁ ଫେରେଇ ଦଉ
Lordship, there is no provision to pay penal damages, Lordship, in liquidation proceedings, Lordship.
Okay, right, add.
I'm not damage asking. I'm asking the interest.
No, Lordship.
One of
They have challenged my adjudication.
This petition involved the following request. Page 14 re prayer achela. From the submission of learned counsel for the petitioner, it appears even though the claim of the now what is the status of this party?
Unsecured creditor, Lordship.
Unsecured creditor
Lordship.
has been taken into a task for the materials available therein. Taking into account the documents in support, the official liquidator came to find the entitlement in favor of the petitioner to 5 crore
22 lakhs
5 crore 22 lakhs
5,338 rupees.
338. However, it is and for there is rejection to the tune of rupees 74 lakhs 42,000, bringing the petition and counsel for the petitioner claims there has been non-consideration of the issue and the 6 allowing this application with appropriate direction. Petition also involves claim towards interest and loss. On the service of copy of the IA 1 of 23, there has been filing of response by the official liquidator. Reading through para 4, there has been attempt to submit before the court that on further examination of papers filed subsequent to the previous assessment, there has been further ascertainment of entitlement of the petitioner to the tune of rupees 74,42,000. In the circumstance, officer liquidator seeks permission of this court, company court, for releasing the amount of further sum of rupees 74,42,000 under the cap of admitted dues. This court therefore finds there is no dispute now in acceding to the claim of the petitioner in the unsecured creditor to the for the release of to the extent of 74,42,000. This court therefore, the company court therefore direct release of this amount in favor of the petitioner by way of bank draft or RTGS.
RTGS, Lordship.
Or RTGS, whichever
Lordship.
is available, at least within a period of 1 week.
Lordship, there is a condition to it, Lordship. My Lord may like to see para 7, page 3 of my report, that they have to give an undertaking that there is no case pending against this dishonored checks, Lordship.
Subject to, this release will however be subject to an undertaking by the petitioner herein no dues clearance or no case is
No case is pending.
No case is pending
Lordship,
in any court of law on the self-same issue.
Lordship.
Also undertaking in the event of pending of any case. Also further in the event of pendency of any case,
will withdraw it. Lordship.
filing
Yes,
proof of withdrawal of such proceedings.
yes,
Lordship,
yes.
obliged.
তাহলে 2 weeks ରଖ ହେଲା ଦେଖନ୍ତୁ ଯଦି ଆପଣ କୋଉଠି ଆଉ କିଛି ପ୍ରୋସିଡିଂ ଅଛି ୱିଥଡ୍ର
Yes.
କରି ଫାଇଲ କରନ୍ତୁ
Yes, I will
affidavit ୱିଥଡ୍ର କରୁ
Obliged.
Or we will give the undertaking that within 1 month I will withdraw all this case.
no first withdraw then close
Okay, Lordship.
take money.
Obliged, Lordship.
Yes. With this okay, so far as other reliefs in IA 1 of 2023 considering the rival contentions of the parties, this court finds there is no lawful entitlement to on such aids.
Lordship.
The benefit claimed under paragraph D stands rejected. C and D stands rejected. Yes, this disposes the IA 1 of 23. IA 1 of 23 is closed.
Obliged. Obliged.
Is any other matter?
Yes, Lordship, I filed a report today. My Lord may like to see my report.
So then what is 10? 10 and 12, they go on filing applications after applications.
No, Lordship, this is not my application. I have filed a report that what is the status
You
currently.
have filed a report.
Lordship.
That I'll come to last. Who is there in, yes, please give this IA 10 of 23, flag 32.
10 was, my Lord, disposed on last occasion.
Yes, so they again show it. Can you read that order?
Last order.
They go on repeating these things. What is the date of order at least?
Last order credit. Lordship, may I just.
Date or order 18.
18-8, Lordship.
18-8 का देखिए उल्टे गया नहीं फाइल उल्टा उल्टे के ऑर्डर दे पूरा फाइल बड़ा ये नहीं दीप्ति नहीं IA 10 of 23 disposed of by order dated 18/8/23 and order number 308. There is unnecessary listing of these matters. Registry directed to set the reporting in order. Yes. Okay, then 12 of there is another application 12 of 23. 12 of 23. Flag 33. କହିଲି ସେ ମିସକେସ୍ ଗୁଡା ତମେ ବାହାରେ ରଖିଦିଅ so that we did not go through any
That is the basic contention, Lordship.
Okay.
Since
They did not respond to the advertisement.
they did not respond. Now they have come up.
Now they have come up.
I have verified. Yes, they are genuine, but they have missed the timeline, Lordship.
Huh?
They are genuine as per the muster roll. Some of the claimants are.
Name appears.
Yeah. That
So
is
you examine and take appropriate decision.
as my lord wishes.
In the event dividends is likely to be released, then the release authorized.
Then I'll have to take the help of that same chartered accountant, Lordship, because the claim has to be
It has to be routed through chartered accountant.
Lordship, because everything has to be verified. My para 5 is.
In your report, you have
Yes,
indicated
para
of
5 is
that.
there. Yes, Lordship. Para 5, Lordship. Today's report.
Para
5. That is the
Five.
last para, Lordship. Yes.
Okay, all right. This is a miscase with following prayer. At the submission of the counsel for the petitioner. Also involve the response of the official liquidator. For the submissions and the report of the official liquidator through para 5. In the report dated 25th August 23, this court observes these are stale applications filed by 5 applicants here only.
5 number of ex-employees. There are different petitions, my lord. Some 30 people have preferred.
12 is only 5 applicants.
Lordship, this is my sincere apologies. Erstwhile, this
So similar applications are also there.
IA 11 is IA 12 now. IA 11 was disposed because last occasion Learned Counsel was not present in the court. Due to non-appearance, it was
Then
dismissed.
that can't be reopened.
Now they filed a similar petition that is IA 12. That is the same petition.
IA 12 is it there on board?
Yes, Lordship. Today.
Okay, all right. This is IA 12.
Yes, Lordship.
This is only by 5. I am holding that.
That is what I have written, Lordship. The IA number 11 is filed by 5 number of ex-employees. But that is in respect of 30 number of claimants, Lordship. Filing has been done.
IA 11 is already rejected.
Lordship, that is my bad because I had to write IA 12 instead of because they were the same.
This is IA 12.
Yes, Lordship. That was
And IA 12 is at the instance of 5 applicants only.
yes, Lordship, but that is with regard to 30 people. 5 people are the petitioner, but they have claimed for 30 people. But they are given
claiming
the
for
certificate.
30.
Yes, Lordship, I have clarified in my
So
report.
where
Lordship.
do you get their details?
Lordship, I have the only thing which is available with me is muster roll now. So that's why.
Okay, considering the rival contentions of the parties, this court find from the submission of report by the official liquidator, the cases of at least what is the number
120 odd, Lordship.
120 odd, including the claim of the present petitioner's hearing, can be considered. But however, the cases have to be examined in the first hand by the chartered accountant, and the release, if any, shall be dependent on the observation of the chartered accountant.
Lordship.
The official liquidator thus claims some time for completing such exercise. This court in the disposal of IA 12 of 23 observes the claimant herein, let the claimant herein and the any other application by this time pending in the
Yes.
hand of the official liquidator may be referred to the approved chartered accountant.
Lordship, the same SPP associates.
I say approved.
Lordship.
Send him. Approved chartered accountant at least within a period of 7 days. No,
8 days, 10 days.
you will send within 7 days.
I'll send within 2 days, Lordship, but the whole exercise requires time, Lordship.
We'll say within 7 days.
Lordship.
Let the approved chartered accountant give his opinion.
Lordship.
Including identification and entitlement aspect, at least within a period of 15 days.
Lordship.
Thereafter.
Yes, Lordship.
15 days. Release, if any, of the dividends in favor of any eligible party involved herein may also be made after undertaking the required exercise and the required compliances
Lordship.
within further 1 month.
Lordship, obliged. But Lordship, only one prayer that today should be the considered last days for filing any claim. We are just approaching
Last date
of filing any claim with us. That is 25th. Right?
return.
Lordship, claim anything after today. I am not going to receive,
Okay,
not
right,
going to attend any.
right.
Lordship.
It is made clear here. Let a main case, a company act. This court observed, even after final conclusion of the dividend issue and the benefit in favor of the shareholders, applications are pouring in. This court earlier already set a cut-off date. Keeping in view some valid applications, some applications are still coming in. This court extending the earlier cut-off date refixes the cut-off date as 31st of August.
Obliged, Lords.
And makes it clear any application comes after 31st of August 2023 shall not be entertained.
Obliged, Lords.
Your Lordship, my clients are requesting, if my Lordship allows, they want the adjudicated amount to stay with it in the dividend account rather than with the ROC.
That is what I have directed.
Okay.
Yes, that is the procedure. It will go like that only.
Yes, I am a director. First, it will be sent to the chartered accountant. He will identify and indicate the amount you are in entitlement. Then within 1 month, they will.
Lordship.
Your Lordship.
Only admissible entitlements.
Lordship.
Rejected.
Lordship.
I may pardon my lord.
Argument koriya darkar podini.
Yes.
I may pardon my lord. I mean, vice my lord, one matter, my lord, that is IA 13 of 23, my lord.
13 is not on board.
My lord, that is on board, but it is mistakenly not named, listed.
That is not on board. I don't have this application on board. That is on board.
That is in flag 33, my lord.
Flag re roile nahi. Jetole asibo dekha jibo. This matter is not going to finish even if I retire. So it will continue. You may file memo, matter may come. Somebody else may decide.
Lordship.
Yes, then let this.
This matter is related to 2015 and Miss case has been filed, and that is case is pending till then.
Close your prospect. The application stands pending.
That is pending.
So let it come after 4 weeks. Because their issues will be there in the meantime.
Lordship, on 4th, my lord, may like to, because I just want to brief my lord. My lord has blessed so much this case. So I just want to brief up before my lord leaves this honorable court. I just want to put up a report.
The certificate is necessary.
As my lord will say. Yes, I just.
What is there?
Okay, my lord.
He is looking everything.
My lord.
We are all duty bound.
My lord, my lord.
So
My
let
lord.
it come.
My lord, as my lord will say.
You may submit. You may submit a report.
Lordship.
Okay, that will be kept on record.
My lord, my lord.
But there is no need of certificating the court.
My lord, my lord.
Then I will go certificating you. We are all working for the
Lordship,
benefit
lordship.
of the others. God will definitely grace
But
us.
lordship, there is one more issue I may be allowed to say. There are 5 cases.
Oh, my time is running out.
Lordship, only one. There are 5 memos I just want to file for early listing of the cases. I filed the dissolution reports. They may come up on 4th of September, Lordship. Only dissolution order has to be passed, my lord.
Okay, list the matter on 4th.
Lordship, obliged. I'm just giving the memos.
4th is a Friday.
4th is a Monday, Lordship. Monday, Lordship.
Sorry, 4th is Monday.
Lordship.
Right, all right.
Obliged, Lordship.
My lord, along with that Miss case.
Rest matters will come on Monday.
Next 24
Monday nahi ki suno. Eta kamo karo. 3 matter kar diyo next week re.
24 je सोमवार आसु it's a already covered matter.
3 matter kar diyo next week re.
Monday
interim order wherever there to continue.
24 is a covered matter, so if your lordship may kindly.
I don't have time now.
No, not today. I was only praying for Monday, my lordship.
କହିଲି serially ଆସିବ ଶୁଣ serially 3 matter ହିଁ ପ୍ରତିଦିନ ଆସିବ
Sir.
ତ ଆପଣଙ୍କର ହୁଏତ Tuesday ହେଇପାରେ ତାଙ୍କର ହୁଏତ Monday ହେଇପାରେ ତାଙ୍କର ହୁଏତ Friday ହେଇପାରେ
Sir, item.
ଆର୍ଜନ ହବ
ନାଇଁ ନାଇଁ sir, ଆର୍ଜନ item 14 ଟା ଆପଣ ଶୁଣୁଥିଲେ ସେଦିନ ମିଷ୍ଟର ଦାସ ଆସିନଥିଲେ ମୁଁ ଦାସକୁ ଧରିକି ଆସିଛି ଆଜି
ଆଜି
ନାଇଁ sir, ମୁଁ ଜାଣିଛି sir, ମୁଁ କଣ ଏତିକି sir ମୁଁ
ଯୋଉ ଦିନ ଆସିବ
ନାଇଁ ଯୋଉ ଦିନ ନାଇଁ sir, ଏଇଟା ଆମ ଭିତରେ କଥା ହେଇଛି ଆପଣ ଖାଲି ଗୋଟେ ଜୁଡିସିଆଲ ଅର୍ଡର ଦରକାର 2 ମିନିଟ ଲାଗିବ ମଣ୍ଡେ ପାସ ଏଇଟା 2 ମିନିଟ ଲାଗିବ
ଶୁଣ ପୁଣି ତା ଭିତରେ ବାଇଫର୍କେସନ କରିବା ଡିଫିକଲ୍ଟ ହବ
ନାଇଁ sir,
ଆସିବ
ଆଜି ଯୋଉ ଦିନ ସେଇଟା
comes on Monday or Tuesday what is
ଆଜ୍ଞା
ଆସିବ ସବୁ ମ୍ୟାଟର
ଆଜ୍ଞା
extension time ଟା କରିଦବ ହେଲା by 2 months provided the matter is yet to be disposed registry to communicate there.
God bless you.